This matter may adjourn for 2 weeks, my lord.
Why?
My lord, due to my personal difficulties, my lord.
The order matters, why has been listed today?
My lord,
Any idea?
there is a miscase for bail, my lord.
Sentence.
Sentence 7 years sentence already. 1 year, 1.6, my lord. 18 months in jail.
Counsel for the applicant slash petitioner. Matter is adjourned for 2 weeks on a date to be picked. Okay.
May it please, your lordship. I have a prayer for listing, my lord, of a criminal petition. The petition involves an issue of cow smuggling case, and my arrest is impending, my lord. So I had challenged that through criminal petition. That was supposed to be listed on 21/6, my lord, but it did not got listed. Can it be listed on the next week, my lord? I need it on the next week, my lord.
Monday. 29.
May it please, your lordship. I beg to mention item number 10. Kindly the matter may pass over for the day.
So the stay order is enforced.
No, my lord. Stay order is there, my lord. Stay order is
So
there.
the 22 matter. Let the matter reach. Yes.
My lord, I'd like to mention one matter, my lord, a criminal division, my lord. It will be listed for orders, my lord, on 31st of July, my lord.
Okay.
May it please, your lordship, I'm paying for listing of this criminal petition for tomorrow, your lordship. It was last listed on 23rd 6 2023, and thereby it was the stay order is operating, and it was supposed to be listed after 4 weeks, but till now it has not been listed, lordship.
26th, Friday.
Obliged.
My praise, my lord, for listing one criminal petition today filed, my lord. My lord, we are denied the cross-examination, my lord, and the my lord, final my lord, hearing is fixed on 1st of my lord, August, my lord.
You want to first get the number.
My lord, I have
You
a
have
filing
the-
number, my lord, 6493 up to 24, my lord.
That is the filing number or the number of the criminal petition.
My lord, filing number, my lord. Just now we have, my lord.
That's why you do it.
Well-
The next date is on 1st of August, right?
My
We
lord.
have time. You make a mention tomorrow or day. You take care.
May I please, lordship? I beg to mention item number 44, lordship. In this case, lordship, my senior Asbo Thakur will assist, lordship, and senior counsel K.N. Chaudhary, lordship, and my senior's father passed away yesterday, lordship.
Well, Mr. Botakur was here.
His father passed away yesterday, lordship.
Stay order is in force.
Yesterday evening, lordship.
Stay order is in force.
Yes,
So-
lordship.
So
So 2, 3,
maybe from the other side.
I have informed, lordship.
Okay, let the matter reach, we'll see. Yes.
May I please, your lordship?
Obliged.
I'd like to mention item for listing of criminal appeal, your lordship, on any date, your lordship, for others, your lordship.
29th August,
Oblige, your lordship.
sorry, 29th July.
May I please, your lordship, with the consent of the respondent, I beg to mention item number 5, lordship. Matter kindly adjourned for 2 weeks, lordship.
It's on a date to be picked. Yes.
Lordship, I may be allowed to move on criminal petition for orders. But I have challenged the order passed in the DB Act.
When was last order passed? When the last?
Last order passed on 20 on the 22/6/2024. I have challenged the order of maintenance and
31st.
Lordship.
31st.
Please, your lordship, my lord. I'd like to mention item number 2, my lord. Petitioner already expired, my lord.
Wait for some time. As soon as the mention is over, we'll take care of it. Don't leave. Pass the order today.
Lordship, I beg to mention criminal revision petition. The matter was last posted 5th December 2023. In the order is my lordship, step already taken.
It is tight, so 7th of August.
Obvious.
Please, your lordship. Lordship, I beg to mention listing of a criminal revision petition on Monday, lord.
When did you file?
Lordship.
When did you file? Matter is pending or it's a new matter?
It is pending, lordship. It was last posted on 15/5/23. This matter is parting to
This matter will come for orders or for admission?
admission hearing, lordship.
Notice have been served in the opposite party.
Yes, Lordship. We have for the respondent, actually, this matter pertain to maintenance, Lordship.
Monday next, 29.
May I please, Lordship, I like to mention for listing of criminal appeal, Lordship. This appeal, Lordship, yesterday listed, Lordship, but not reached, Lordship. Here in this case, Lordship, the urgency is that, Lordship, the appellant is on previous bail, Lordship, and which is and tomorrow, Lordship. Tomorrow is fixed for necessary order in the trial court, Lordship. So, Lordship, may take today or Lordship tomorrow, Lordship. Yesterday it was listed but not reached, Lordship.
It is in hearing stage or it is in admission stage?
Admission stage, Lordship.
Tomorrow.
Deeply obliged.
I will question. Day of surgery. Stage. Okay, number 2. Yesterday, which item number?
Item number 24, Lordship, in court number 21, Lordship. Obliged.
Yeah, beg your lordship. Lordship, I beg to mention a criminal revision petition for listing, Lordship. The urgency of the matter is that the wife of the petitioner has
It's
filed.
pending, it's a new petition or it's a matter?
It's pending.
31st.
31st. Much.
Yes, ma'am.
May please, your lordship. Lordship, I am praying for listing of this criminal revision petition in the orders column, Lordship.
31st. Yes.
Hare Krishna, Lordship. My lord, item number 7 may be adjourned for the day. My lord, I'm for the respondent number 2. I will file affidavit on next date after 2 weeks.
Yes, I am for the petitioner, my lord, in this case, my lord. After 2 weeks, my lord, please. Obliged.
May I please, your lordship. I beg to mention item number 29, Lordship. This matter become infectious, Lordship.
Wait for your turn. We'll pass the order immediately after the mention is over. Yes, ma'am.
May please, your lordship. I beg to mention the item number 48 may be adjourned for today.
Why it has been orders today? Item
Mr.
number?
48,
Why it has been listed for orders today?
due to personal difficulties to Mr. K.
Why it has been listed for orders today?
We have filed IA for substitution of next year.
For the opposite counsel, the IA was filed by them for the substitution because the proprietor, the petitioner has died in January. So we have filed the objection in the last date and today they are not able to do the matter. So
Have you filed objection to the substitution?
filed the objection.
The priority council for the after 2 weeks. Okay,
Any date?
we are not fixing the date. Registry will give the date after 2 weeks.
May I please, I beg to mention item number 28. Lordship. Matter may be adjourned for the day, Lordship. We could not find out the official file, Lordship, due to recent shifting of chamber.
Just doesn't matter. Let the matter reach, we pass also. Don't worry. Yes, ma'am.
May I please, your lordship, item number 8. I, on behalf of RDIP, my senior is out of station. I pray for an adjournment for a week.
Yes, you can sign off. Wait. Wait. The council for the. Anthony. Yes, yes.
Lordship, I beg to mention item number 44. My lord, Mr. Elgotabo is under bereavement. Lordship, I pray for after 2 weeks, Lordship. I have taken consent from the RSL, Lordship. Allowed.
Someone made a mention. We'll pass the order. Don't worry.
Lordship. Hello, Lordship. Item number 2.
My lord, item number 2, petitioner already expired, my lord, in the month of January. 22 January 24, my lord. We want to what is the matter, my lord?
I am for the respondent number 2, my lord.
Mr. M. Islam.
Yeah, Mr. Lord.
Counsel appearing for the petitioner. And I'm S. Zahan. Surrounded. Additional public prosecutor. State respondent number 1. Also heard Mr. Ayalam,
T shake, my lord.
sorry, T Sec, learned counsel for the respondent number 2.
I hope this 138 gets abated. I don't know, because he has to get his money.
Already expect criminal.
No, automatically this order stands vacated unless the complainant
পইচাটো তুমি দিবলৈ আছে না পইচা কি কি হ'ব এবেট হয়নে নাজানো দেই
Expired on 22 January 2024.
But Mr. M. Islam, counsel for the petitioner, and Mr. T. Sek, counsel for the respondent number 2/complainant. Submit that the petitioner expired on 24th of January.
22 January
22nd
24.
January 2024. In view of the above. That's criminal division petition. Being in process. Registry shall return in the records of criminal appeal number 15 of 2018. The court of London additional session judge within bracket CrPC Kachar. Portrait along with a copy of this order. আৰু এটা আছে এই তাৰ আগতে সেই ৰেকৰ্ডৰ আগতে ইনকুৱাৰী মত 11/24/02/2020
Like
somebody was here for 29. Mr. Ali, it seems it's not so.
Lordship,
Why?
well, trial has already been completed.
Heard Mr. Ali, counsel appearing for the petitioner. And I'm as the Honland and additional public prosecutor appearing for the state.
এটা কিমান
29.
29
Mr. Ali, grant counsel on appearing for the petitioner on instruction of the petitioner submitted. Instruction of the petitioner. That during pendency of this
29
criminal petition,
একাব্বর আলী
the proceeding of Haligaon Police Station case number 177 of 2022.
ট্রায়ালে ওভার দিলে ইনফ্রাকচার সার্ভিস
On 772022.
ইনফ্রাকচার্স
Before which court? Mr. Ali, can you tell us?
Hello.
Before which court? Do you have the instruction?
My lord, in the court of judicial first class Sirang, my lord.
Do you have the number?
PRC number we have, my lord.
Hmm.
PRC 06/2023.
Here, corresponding to
Charge sheet 103/2022.
062022.
Lordship 06/23, my lord. Public
23.
2023.
23. Has already been completed
JMFC Sirang.
before the Court of London Judicial Magistrate First Class, Chirang. In view of the this criminal petition being in. Okay.
All right.
Mr. Sharif is not there.
Abu Sharif.
Hey, Sharif.
Yes, I'm
It
the
should be Abu
respondent.
Sharif. Okay.
Respondent 1 and 2. 2 and 3. Juvenile, very good, it was with very good secretary. Classroom,
Abu Sharif. Abu Sharif is not alive, I believe.
Able to locate.
His junior is
Abu Sharif.
Other names are there.
they are
Abu Sharif.
I think he has expired.
Expired.
I think he
Belek Sharif open. F Islam A Alam. M Alam.
You are appearing for whom?
Respondent number 2 and 3.
Which is against declaration of the accused as a juvenile.
Juvenile.
Since ossification test was done.
Since 2013, the stay order is in force.
To Sindhupa. Let him give a try and call up the petitioner side.
I do not know. Actually, never.
Directory pass I F Islam all.
Nine, I'm not telling. There are other options. There are other options. Or at one. Number 9.
Ms. Zahan, date of the incident was 22nd of June 2009.
2nd June 2009, Lordship.
There is also a second occurrence, but let it be first occurrence itself. Continuation occurrence, so 21st of July 2009.
This is a continuation.
Ossification test was done on pursuant to the direction of the learned additional session judge. It was done on 10th of January 2013.
10th of January. Yes.
2013.
13.
And he was found to be above 20 years
Yes.
on,
Above
that is in
20
January
years.
2013.
Above 20
After
years.
4 years of the incident or 3.5 years of the incident.
Yes.
So necessarily at the time of the incident, he was a juvenile.
Juvenile.
And further, the higher secondary certificate of the accused also reflects that he was juvenile at the time of the incident.
Yes.
But in absence of the counsel for the petitioners, we cannot pass any such order at this stage.
Now, what grounds they have taken, I just wanted to find out that. He managed the headmaster of the school, he said. Paragraph number 9, he said that he had managed these certificates and then so big will you come in?
No, the petitioner agreed because the juvenile board considered the petitioner respondent number 1 to be a juvenile.
Yes. But then what I see, the process has been properly followed. Their wakalatnama may be there, where we can find the complete name of the other two counsels.
Yes, yes, it is there. Just a minute. We'll just see one more.
Okay, contact for file hai. हाँ, ये director प्रभाने.
এটা একটা petition দিচ্ছে। Before to wait, will wait.
Between the relations, above 20 years, how much?
Petitioner wants to rely upon a particular certificate issued by one headmaster of Sakir Bisha Higher Secondary School without any date. There is no issue number, nothing, no pad. Stating that the petitioner number here, respond number one was, date of birth was 9th of March 1992. But that cannot be because his higher secondary pass certificate, that will be on the basis of matriculation certificate,
High school. No, higher secondary or officer.
has to be
এটা হাই স্কুলে মূল পরিষদ হাই স্কুল ওটা হাই স্কুল হাই সেকেন্ডারি স্কুল হাই স্কুল 8-9 কইব এনে তো এটা প্রাপ্ত হয়ে থাকে রেকর্ড বিশাল
These are certificates by
হেডমাস্টার রিটায়ার হয়েছে হেডমাস্টার রিটায়ার হয়েছে বর্তমান না
এটি স্কুল সার্টিফিকেট হবো জানো
এটি ডেট অফ বার্থের উপর ধরে দিচ্ছে ট্রান্সফার সার্টিফিকেট দেওয়া নাই লিভিং সার্টিফিকেট দেওয়া নাই ডেট অফ বার্থ
But according to section 94, this will not come within section 94, the certificate given by the headmaster.
definitely not.
Therefore, they went for ossification.
Ossification, if it was ossification, 20 years.
Okay.
20 years.
As told by.
Let's do
Our
integration.
innate conclusion was by seeing Eburaru,
Above 20 years.
artillery, side.
Above 20 years.
Above 20 years is otherwise safe for everyone.
That previous to be one or
When I thought 20 to 22, and I get developed on the basis of physical, including dental examination and radiological.
As per the Board of Secondary Education, this is class 10, not the higher secondary. His date of birth is 30th of December 1991.
Into ossification, how much?
So I don't know.
Yeah, background no other for a radiological test. According to this report, the age of will be 25, 26 years. It may be said that the report is vague. It is therefore said to part of the
25, 26,
estimation report. The ossification, no, age estimation report.
As it still.
I'll have to check. This is an age estimation report. Whether age estimation report and ossification are one and the same thing.
No, after all, the order of the revision court has not been challenged.
That has not been challenged. So he had filed an application saying that this estimation is vague.
Wait.
What happened to this application? We don't know.
Juvenile border.
Both the respondents are the son of their brothers. Accusation against him. The respondent number 2's date of birth as per the Board of Secondary Education is 9th March 1992. Whereas the respondent number 3's date of birth is sorry, 15th. The double hop. 15th of February 2008. So this is the secondary education board certificate. And this is more having more weight than the certificate issued by the school. In fact, the name of the school is not there, no issue number, nothing. But anyway, will not go to that extent. None appeared for the petition on call. Heard. MSS Zahan Lawrence. Petition Public Prosecutor for the state respondent number 1. And Mr. N. Ahmed, Learned Counsel for the respondent numbers 2 and 3. The history shall reflect the name of this is the full name of the counsel for the petitioner. Namely, Abu Sharif, Fakhrul, FAKH, Ariel, Islam. Samsul Zaman, SAM, SUJ, JDMAN. Deposit list. Totally, none appeared for the petitioner report. No names of 3 counsel. And M. Alam, sorry, number 11, M. Alam. List on. 5th of August. Diploma.
The question
Yes,
matter
Mr. Walker.
arising out of a private complaint, just before vacation, my lord, the opposite party filed an affidavit. So the affidavit has been given to my client for her comments, whether to file a reply if advised. But presently she is under treatment, my lord, she is having cancer. She is a cancer patient, so not available. for comment, my lord. So I pray that the matter may be listed after 3 weeks. And meanwhile, if advised, my lord, we will file a reply.
Where is the complaint, page number?
Page number 11.
Page 11 is the complaint. It was an agreement for sale of a plot of land. Normally, for not giving effect to such agreement, legal remedy is to file a suit for a specific purpose.
That's right.
So, my lord, let me see, they have also brought in certain allegations. If necessary, we will file a reply affidavit. And as per their own complaint, it appears that on 9, they sent a notice under 80 CPC also. No? They have a legal notice.
Okay. Yes. We'll hear you. But whether this will sustain or not, find out. Whether this petition, whether your complaint petition will sustain or not.
Yes, it will sustain, my lord. There are settled laws, it's a settled position of law that merely having some civil remedies would not wash away the criminal liability, my lord. Yes. I'll address your lordship on that, my lord.
Okay. Mr. Baroda, we'll have it sometimes on 9th of August.
Can it be after 15th, my lord? 3 weeks. 3 weeks.
Up to 15th.
My client is having some.
Okay, in that case, 19th August.
Lots.
On the prayer of the council.
For admission here, yeah?
No, it will come for it. Maybe. Yes, Mr. Krishnan.
Lordship, before going to the facts of the case, Lordship, the matter was, may I pray, Lordship, the status report may be called for, because the petitioner approached before this honorable court for passing of an FIR. And since there is no stay in the case, Lordship, so I am not sure whether still investigation under pending for investigation or charge sheet has been given in this case, Lordship. So status may, because matter was not listed for long back.
Status report was already called for. That was way back in 21. In fact, Lordship, there is a record here. Perhaps the registry has brought it. The record is here.
No, long back. This is a copy of the case diary.
I can take the instruction whether the charge sheet is
That
filed
will
or
get
not. Did it come up at 2 at then today?
No, not.
Acha.
Why don't you want it today? Only that information. Okay.
পুরা মামলা।
মোটা ক্রিমিনাল কথা ছিল মোট টোটাল দৈর্ঘ্য
We'll have it on fifth,
Lordship,
on the prayer of the council for the
Lordship,
petition, on fifth,
information to. কি হয় কেস নাম্বার?
on the same day.
ও এটা ডগ হাউস।
The officer in charge of Borsuk Police Station.
Lordship PS 193.
Shall apprise the court pertaining to the status of Borsuk Police Station case number 193/2021. Present status, up to date status, up to date status of Borsuk Police Station case. Registered the sections 294, then bracket small a, public 507 IPC. Read with section 11, within bracket 1. Read with section 11 लिखा ना of the prevention of the cruelty animals act. Copy of this order be furnished to Mr. M.S. Dahan for her necessary use. Okay.
Obliged, Lordship. Thank you, Adjournment.
Your Lordship, kindly pass over the matter for the time being.
Yes. No, I don't have copy.
Divorce or like to mutually understanding how you
Divorce. Family matter.
Okay, Ms. Jahan,
Lordship.
nobody appeared for the respondent.
There is no respondent here as I can see from the cause list. I didn't know.
Just-
Unsure. I think it's a joint petition.
It's a joint petition.
Not sure. There is settlement, I'm told. Nachima. Nachima is there, yes. The joint petition. Angshu, Jahur, China. Nachima. Divorceable.
No, actually, no.
Or they are saying divorceable. There is a deed of divorce. They have divorced each other. Appellant number 4 and 1, or petitioner number 4 and 1. The affidavit is at page 26, annexure 5. The agreement between them. I can't remember original. Affidavit in completion.
Ms. Zahan,
Not sure.
uh, the victim is not a signatory to the affidavit.
Affidavit, that I have seen. Only Anshu had signed it. And he has not written also on their behalf, he writes, but not specifically that,
By the victim.
yes. It's only, I have seen this.
Then,
And allegations are writ large, even in the case diary, I have seen the statements. Let them file a proper petition by taking the proper affidavit.
or they can personally appear, but somebody has to again identify.
Yes,
That will be difficult.
otherwise it will be a little risky. In the original affidavit, concern?
Order Ms. Anjay Begum,
Matthew Nadelegberg.
counsel appearing for the petitioners. And I must let Jahan learn additional copy of for the sole responsibility. On the basis of an FIR, public FIR written complaint. Laws by direction number 4, petition number 4. Before the officer in charge of the Udharban police station. On thirteen 1/2020. Udharban police station case number 16/2020 under section 498 /307 IPC was registered against the petitioner numbers 1, 2, and 3 corresponding to GR number 209/2020 PRC number. PRC case number 2098/2028 2098/20. After investigation of the case, search sheet was filed by Adjournment Police in said Adjournment PS case number 16/2020 on 18/03/2020 by number 30/2020. The learned judicial magistrate learned subdivisional judicial magistrate within bracket Sodor bracket close. Kachar Silsar inside PRC case number as and such. Issued summons to the petitioners number 1 and 2. It is submitted by the petitioners number 1 and 1 to 3 that in the meanwhile an agreement was executed between the petitioner number 1 and the informant victim, petition number 4. Informant was executed on 13/01/2022. A deed of divorce between them on 13/01/2022, as well as deed of relinquishment of their marriage, that too on 13/01/2022. And as such, all the three accused persons and the informant victim jointly as petitioner numbers 1 to 4 filed this criminal petition for passing of the said PRC case number 2098/2020 under section 498(8)(307) pending before the SDZM in bracket S. Kachar Silsar. While issuing notice on 28/03/2022, the court stayed the further proceeding of said PRC case number 2098 pending before SDZM. Kachar Silsar. It is seen from this petition that the informant victim is not the signatory to the affidavit. While this in criminal petition. Moreover, such deed of divorce between the petitioner, accused petitioner number 1 And the informant petition number, informant slash victim. Petition number 4. As well as deed of agreement. And the deed of relinquishment. All dated 13/01/22. Signed by the parties, signed by them. Allegedly signed by them. Neither notarized, not shown before the authority concerned. In view of the above, both the petitioner number, accused petition number 1 and the respondent number 4 plus informant victim of the urban case number 7 are directed to file a joint affidavit in presence of witnesses shown before the notary. Duly notarized on proper identity, on their proper identification. Such affidavit shall be filed on or before 22nd, placed on 28 August. Sometimes I feel this our bar, Mr. Mahanta, something you should do from the bar council side. You have been doing many things. So here is a case, charges of 498 and 307. The accused petitioner filed a joint petition with the victim. He is from Udarban, Kachar. Someone somewhere has obtained his signature. We do not know. A notary has signed. No identification. Our seniors is to guide us when somebody is to swearing an affidavit, because at that point of time there was no notary.
Yes.
We used to do it before the affidavit commissioner.
Only what commissioner?
We used to say station at Guwahati. Whoever is to come down to Guwahati
Yes,
and to
yes.
identify. Today's council, sir, simply files an affidavit. Though person is from Udarban, Kachar, obtains his signature, no identification, nothing, and the shown before the notary at Guwahati.
No, my lord, that notary also, my lord, they has to also look into.
That it has to do, but hardly they are doing. They'll just register, that's all. No identification, nothing.
In a
And the advocate's clerk is to identify.
Yes. Advocate clerk has to identify. And there is a clerk, there is a specific, there is registered clerk, they have a specific number.
So basically, they should specify who is the concerned registered clerk. Because the advocate's clerk is also having a license given by the
That
concerned
has to be
advocate.
renewed.
Absolutely, they have to be renewed.
But so far as
That-
notary is
that-
concerned, my lord, notary is not directly under the Bar Council of India. But so
Nothing.
far as their advocate license, we can do something.
That is why the
If there is a
concerned
complaint.
advocates used to
But so
give
far
that
as
license,
notary is
right?
concerned, state of Assam, my lord.
So these are the difficulties been seeing, because these are criminal matters.
My lord.
And if the lawyer counsels from the bar is taking it lightly, we do not know something
My lord,
else. may
very
happen.
difficult, yes, my lord. Has to be, my lord, because otherwise.
And
my lord,
earlier also, we have seen when the government of Assam is to cancel this notarized certificate. It
Yes.
doesn't extend the license. They is to come before the court against the order of the government. But there are difficulties.
My lord.
But that will be standard of the bar.
Standard is, my lord, yes, absolutely. My lord, concerned, my lord.
Bar doesn't
Concerned advocate who filed this appeal, my lord, he is also, my lord, he is also responsible, my lord.
So here is unbelievable thing, right? Anyway, just pointing it to you because you are concerned with the bar and the bar council.
Lordship has not closed the matter.
We have not.
Yes.
We have asked them to file a press affidavit.
Lordship.
Duly notarized, duly identified, thereafter we'll consider. And we have fixed the date on 28th of August.
Lordship.
Such affidavit shall be filed on or before 22nd. Yes, Mr. Biswas.
Was a 9-2.
Actually.
You are a good writer. You write lots of obituaries. We read in newspapers. Sometimes you should bring
Yes,
it to the
yes.
notice of the
That has to be
public
looked
also,
into.
how these things are happening regarding such kind of affidavit. So the public will be aware.
Affidavit is a very important piece of, my lord, important piece, my lord. You have
It is
taken
why
note. So
specifically
it
in
has
the
to be,
CrPC
my lord, identified properly.
There are, see, basically technicalities, if you see, this is not a writ petition, right? It's a criminal matters
Criminal
where the
matter.
charge is filed. Anyway.
May I
Yes,
please-
Mr. Viswas.
May I please, Your Lordship? This quashing petition relates to a share case filed by the informant before the judicial magistrate at Karimganj. And there is under.
Let us see, where is that? Where is that complaint?
I am showing, my lord, kindly. Case koto? 19, please, my lord. 19.
19. There's the complaint petition. Okay.
And
Just a minute.
Complaint is 21.
Ms. Jahan,
Your updated case.
straight away come to page number 23. The prayer. Kindly read.
Therefore, it is free to entertain the case and further be pleased to forward the case to the OC, Karimganj, with the direction to register the case and investigate. Acha 156(3).
So, before approaching the first police station, first or the SP second, how this can be registered? Law is well settled.
No,
Not
that
only
is true, my
second,
lord.
so
That
many
is- that is one aspect of the matter, my lord. But my lord, why magistrate has committed a wrong? It should be taken as a complaint case, my lord. He should have done it, my lord. He should have done as a complaint case, my lord.
The prayer. The
No,
itself.
that's more, that was your lordship kindly see that judge is also, my lord, trial judge also, my lord, look into the matter.
You can.
So that's why, my lord, and because of that, my lord, that entire proceeding should not be good. It should be run as a, my lord, a complaint case, my lord.
That is why the law is settled.
No, suppose, my lord, this, that is committed by the lawyers, suppose. My lord, that does not mean that that crime is not been committed. Same land, my lord, he sold out to two persons, my lord. Same land, that is the crux of the matter, my lord. But that has to be run as a, my lord, complaint case, my lord. Suppose if I file a complaint, maybe my payer may be rejected, but he has to, my lord, proceed with a complaint case, my lord. On that ground, my lord, entire, my lord, complaint will not go, my lord.
What can you do when the law has been settled by the apex?
No, my lord, that has to be, my lord, on that point, my lord, there has to be, yes, my lord, your lordship has to be looked into, my lord.
What is the
Please
alternative?
to entertain the case, my lord. Yes, the first part, your lordship kindly see.
What is the
That magistrate
alternative?
has committed wrong, my lord, then.
What is the alternative? That's the trial.
No, then, my lord, your lordship can directly to proceed as a complaint case, my lord.
How can it be done when the prayer is such?
No, prayer, your
Unless the
lordship, therefore, the
complainant
prayer is
seeks a
to
separate case.
entertain the case. That your lordship kindly first part you can accept it, my lord. If, my lord, whatever I pay before the court, everything granted, that is not been, always it is not been granted everything, my lord. My lord, court has to be looked into, my lord. In that manner, my lord, your lordship kindly see the content, my lord. It's a clear case of fraud, my lord. The same land, my lord, the owner has sold it out to 2 persons, my lord. That has to be looked into, my lord.
My lord, civil suit is going on.
The civil suit is different thing, my lord. What that has it been between, my lord,
Challenging the
person.
sale proceeds.
But how he can sell 2 persons, my lord? Is it not a fraud, my lord? My lord, my submission before your lordship, my lord, it has to be, my lord, ran as a, my lord, complaint case.
What will you do? Listen to our order. It will be better.
But our own High Court case, Torun Dev Sharma is also.
Justice C.R. Sharma's judgment.
Yes, I have seen, my lord, that Priyanka Srivastava case clear. But your
There are
lordship
many
kindly,
judgments.
only for that, my lord, that remedial, my lord, he is. Because of the fault of the man who has filed.
Remedy will get in civil court.
No, civil court is different, my lord. What is his criminal liability, my lord? Is it his scot free, my lord? He is knowing fully well that he has sold out to 2 persons in the same land. Is not a crime, my lord.
Instead of filing FIR, you have directly filed a CRK. You could have filed.
Mr. S.C. Viswas, learned counsel appearing for the petition. And M.S. S. Zahan, learned additional public prosecutor Assam for the state respondent number. Also heard Mr. T.J. Mahanta, learned senior counsel, assisted by Mr. A.K. Azad, learned counsel for the respondent number 2 plus complainant. This criminal petition has been filed by the petitioner plus accused. Being aggrieved with the order dated 17/02/2022 passed by the learned subdivisional judicial magistrate within the Sagar close Karimganj. In CR case number 183/2022. Whereby the learned magistrate, after hearing the complainant, respondent number 2, invoke the provision of section 156 within bracket 3 of the Code of Criminal Procedure, directing the officer in charge of Karimganj Police Station to register a case on the basis of the said complaint to investigate the same and to file a report. On the basis of said order, dated 17/2/2022. Complaint of the respondent number, the complainant, respondent number 2 was registered as Karimganj Police Station case number 0127 of 2022 on 22/02/2022 under sections 420/468/506 IPC corresponding to year number 425 of 2020. The alleged accused submitted that the order of the magistrate Karimganj first instance here case number 183 of 2022 on the basis of the complaint lodged by the respondent number 2 against him is in violation of the provision of the law laid down by the Honorable Supreme Court. Next. The respondent number 2 on 17/02/2022 filed a complaint against the petitioner, before the Learned Chief Judicial Magistrate Karimganj, being CR number 183 of 2022, along with a sworn affidavit stating that the accused / petitioner herein sold 5 Zotis ZOTIS 9 Gonda JLDA of land with RCC building over it, covered by old dog number 146 and 147, under Khatian number 17 and 18, and new dog numbers 229 and 208 of Patta numbers 147 and 149, under Moza Sabek SAB along Zuri at present within Karimganj town to the complainant by registered cell deed number 5240 dated 09/12/2015 for a sale price of rupees 25,00,000,000 and delivered the possession of the land and the RCC building to the said complainant. Thereafter, the complainant took over the possession. Thereafter, the complainant, after taking over possession of the said land and building, RCC building, took electric service connection by consumer ID number 0130000138884 in his name, and let out the said building to a tenant the complainant has also obtained mutation over in his name and the said purchased land from the accused, as well as building, land and building. And the records of rights over the land was duly corrected in his name, with proper holding number. And with proper holding number in the concerned panchayat. So the accused petitioner number 1 during the said sale process to the complainant specifically mentioned in the concerned registered sale deed number 5240/2015 noted above that said parcel of land and building and the building over it were free from all encumbrances and not mortgaged with any bank/financial institutions. এই যে উপর 5240 লিখবো প্রথমত লিখেছে after obtaining necessary permission from the office of the deputy commissioner, necessary permission oblique no objective certificate from the office of the deputy commissioner Karimganj, file number KDA/LS/NOC 297 dated 08/12/2015. However, on 25/01/2022, the authorities in the Punjab National Bank, Karimganj branch, hanged a possession notice under CrPC Act in his said building premises stating that the land and building that he purchased was mortgaged with the said bank, erstwhile United Bank of India,
By the accused.
by the accused. And as such, only on 25/01/2022, the complainant could come to know that the accused petitioner number 1 had cheated him. While executing the sale deed number 5240 dated 9/12/2015 of 10/12/2015 and committed an act of forgery, an act of fraud and forgery upon the complainant. In the said complaint, the complainant respondent number 2 also alleged that the accused/petitioner number 1 threatened him and treated him to cause injury and harm on his person if he lodges any such complaint against the said accused And since there was the marriage of his daughter, the complainant and respondent married the daughter on 11/02/2020. The complainant respondent number 2 could lodge the complaint against the accused petition number 1 only on 17/02/2022, submitting before the learned Chief Judicial Magistrate Karimganj. To direct the officer in charge of Karimganj Police Station to register the case and investigate the said case properly and to arrest the accused person. Otherwise, he shall suffer irreparable. It is seen from the records of it is seen from the annexes appended to this petition that after hearing the complainant, the learned SDJM within brackets Karimganj on 17/02 the learned CJM Karimganj on 17/02/2022 transferred the said CR number 183/2022 to the Court of Learned SDJM within brackets for disposal. On hearing the complainant respondent number 2, the learned SDMS by order dated 17/02/2022 passed in said CR case number 183/2022. Considering the prayer made by the complainant respondent number 2, forwarded the said complaint under section 156(3) CrPC to the officer in charge of Karimganj Police Station to register a case and to investigate the matter. And to submit the report in final form. Accordingly, the said complaint of the respondent number 2 within brackets CR case number 183/2022 was considered to be a written FIR and by the officer in charge of the Karimganj Police Station and registered the same as the Census Operative, Karimganj case number the second circumstance corresponding to GR number 425. The petitioner, the accused, filed an application for bail under section 438 CrPC before the learned session judge Karimganj, being bail 438 case number 95/2022. And on perusal of the case there, and the materials in it, learned session judge Karimganj by order dated 15/03/2022 Past in said bail number 438, bail 438, case number 95 of 2022. Rejected the anticipatory bail of the petitioner, finding sufficient materials against the petition. Thereafter, the petitioner preferred an anticipatory bail application, the section 438 CrPC, before this court, and by order dated 30/09/2022, being AB number 839 of 2022. Yeah. And a court on 25/04/2022 passed in said AB number 839/2022 granted interim protection to the petition. And after considering all the materials in the case diary, hearing the parties, the court by order dated 30/09/2022 passed in AB number 839 of 2022, rejected / dismissed the anticipatory and the materials in the case. Rejected the anticipatory bail application of the petitioner, vacating the interim pre-arrest bail granted to him earlier on 25/04/2023. Noted above. Thereafter, the petitioner on 28/10/2022 filed this criminal petition. Ms. Jahan, it is 2008 to SCC. Sakiri Vasu. 409 probably.
2015 8 SCC 287.
That's the
2015
Priyanka Srivastav.
2015 6 SCC.
There is also a judgment of the 3 judges bench of the Honorable Supreme Court. Can you remember that? Don't have it with me. No, Mr. Mahanta, these are all these cases that you have placed it over.
Yes.
These are without the affidavit.
Yes, that is also done.
But thing is this, it's not the case. Case is that if you do not approach the police station first,
Yes.
and if you do not approach thereafter the SP, as provided under section 156, You straight away cannot file an application under section 156(3) because
Exactly.
that's the law.
Yes.
So these are the cases in the Priyanka Srivastava's cases. It is that there is a requirement of filing an affidavit.
Exactly.
Here there is an affidavit has been filed.
But no.
In this case, because the record is before us that this affidavit has been filed.
This is not that affidavit.
Correct, ma'am. Affidavit is filed, but
While filing that complaint, affidavit has been filed. But thing is this, there is no mention in the complaint that the complainant earlier approached.
in that affidavit, my lord, rather, my lord, says that I have not went to the police station. Your lordship kindly see the affidavit. That line is trouble me, my lord. Your lordship kindly see the affidavit, my lord.
Yes.
This is not that affidavit. That affidavit is specifically if he has not approached any.
We should not to
But page 24, you will get it. Right?
No, that's true. That's the law. Law is that he first approached the 156.
Exactly. Page 24, he said, I have not approached the police station.
I do further declare that I have not lodged any complaint under section 2020.
Yes.
Any police station or before criminal court. No, I am not denying the law. Law is yes, my lord. That is correct. But my lord, that's my lord basis. Should have my lord continue with the complaint on this line.
I remember 2008 2SSC. I didn't remember the page, I think. So that's why I was looking for.
GLD.
Law is well set. That. An informant is first required to approach the concerned police station to lodge an FIR under section 1. Police service. Thereafter, if no such cases registered or no such investigation is made, the informant under section 156(2) of the CrPC can always approach the superintendent of police, the district concerned, by making necessary representation with registered post with the said authority as provided in section 156(2). And without complying the provision of 156(1), 156(2), a complainant plus informant stative cannot approach the court under section 156(3). Praying before the magistrate to forward the case to the officer in charge, the concerned police station, directing to register the police case and to investigate the matter. Including arrest of the accused, etc. Arrest of the named accused in the said form. Emphasis submitted liquidly. Sakiri Vasu SAKIRI VS versus State of AP. Within bracket. Reported in liquor 2008 to SCC 409. The Honorable Supreme Court. Subsequently, in many such cases, including the case of Priyanka Srivastava and another versus State of Uttar Pradesh and others, reported in 2015 6 SCC 287, as well as in the case of Babu Venkatesh and others versus State of Karnataka and another
That is, my lord. That is
affidavit.
not unreported. That is the judgment, my lord. I have not. If there are 25, 26, and 27.
Report in
my lord, there is a
2022.
affidavit. If there is a affidavit, that has to be verified by the magistrate. my lord.
5 SCC 639. Dealt with the provision of section 156 3 of the CrPC. True. A coordinate bench of this court passed earlier. Also, the case of Tarun Chandra Sharma. Do you have that citation, GLT citation? Tarun Chandra Sharma.
Yes.
Tarun Dev Sharma.
Yes, madam.
2015.
It is, yeah.
Dealt with the matter relating to section 156 3. In the case in hand, the complainant do file the complaint before the learned magistrate on 17/02/2022. In the affidavit that he shown accompanying the complaint petition clearly mentioned that he did not lodge any criminal case under section 420/468/5206 IPC at any police station or before any criminal court till the filing of the said complaint petition. Considering the law settled by the Honorable Apex Court and by this court earlier, noted above, and the provision of section 156 will indicate 156. The court is of the view that the order of the learned as subdivisional judicial magistrate in Sadar Karimganj dated 17/02/2022, passed in CR case number 183/2022, directing the officer in charge of the Karimganj police station to register the said complaint of the respondent number 2/complainant as an FIR and to proceed with the investigation. Cannot sustain in law. Full stop. Accordingly, this criminal petition dismissing or been allowed to the extent in setting aside the said order at 17/2022 passed by the Subdivisional Judicial Magistrate within Sadar Karimganj in CR case number 183 of
The one judgment, Villas
since
judgment. You must kindly para 37, you must kindly.
which one, Babu Venkatesh? Babu Venkatesh?
No, Babu Venkat, no, that is Babu Venkat already have placed.
Hmm.
Villas Vijaya.
Do you have the citation?
Yes, my lord, I have a copy, my lord. You must kindly see in that case in a similar situation, my lord, there is a prayer to my lord, send it to.
That is what we are doing.
But in that case, my lord, court has, my lord, sent it to the magistrate to rethink again, my lord.
No, no, what we will be doing
Page
in a different
37,
way.
para 37, can you, your lordship, can you see that? Page 30, para 30.
We are setting aside that order of the magistrate only.
Your lordship, kindly see the para 37, my lord. We do not intend to go into the question of merit of the allegation and what the procedure of magistrate should have followed. The inspector of judicial magistrate must first consider and decide the judiciary as per law. What is impermissible and contrary to the laws and adjudication on merit, allegation and determination that in fact invested without further scrutiny of the examination. Therefore, the High Court was correct in remitting the matter of the judicial magistrate for further examination.
That is, just a minute. Just.
Para 40 also, my.
Mr. Mahanta, please come to para 2.2. In that background, when the authorities fail to perform their duties, so you file an application before the CZM under section 156. So after complying 156.1, 156.2, so the victim therein approach the CZM after under 156.3. So how the cases differs, right? The thing is this, that's the law. 156.1, 156.2, then 156.
Correct.
So here is a case where the earlier, the victim approached the DCP. Then it was not done. So then she also approached the concerned police station. It was not done. That's why 2.2, and therefore the CZM, the Honorable Apex Court directed the CZM to reconsider the matter. Okay, that's the facts of the case in that particular matter. But anyway, we'll give you some handle. Don't worry. During the deliberation of the matter, Mr. Mahanta Lanit Senior Counsel appearing for the complainant respondent number 2 also placed reliance in the judgment of the Honorable Supreme Court in the case of Kailash Vijay Vargya, Vijay versus Raj Lakshmi Chaudhary and others. Just a minute. This practice is going on regularly. Yes, that is true. within bracket লেখা criminal appeal numbers 1581/2021, 1582/2021 only 1581, 1582 and 1583 of 2021 decided on 04/05/2023. Reported at Manupatra tax retailer Manupatra small ma'am likheba italicized koribo capital Manu all capital MANU /SC /0527/2023 that the matter can be remitted to the judicial magistrate concerned for further extension. It is said to since the said order of the Honorable Magistrate has been now passed. Consequently, the Karimganj police station case number such and such corresponding to tier number 425/2022 registered and investigated on the basis of the said order of the Honorable Magistrate. Also will have no effect. But considering the order of the learned session judge Karimganj dated 15/03/2022 passed in bail application number 438 bail 438 case number 95/202 as well as the order of this court passed on 30/09/2022 in case number AB number 839/2022. If it is up to the respondent number 2/complainant to approach the appropriate forum, including the officer in charge of Karimganj police station, Karimganj, and the learned chief judicial magistrate, Karimganj. File appropriate application against the petitioner, the accused petitioner, in accordance with law, considering the fact that the complainant respondent number 2 approach the chief judicial magistrate / as designed as wrongly approached by preferring application under section as and that they run it as designed. Karimganj considered the said complaint of the complainant respondent number 2 under section 156 3 of the CrPC. and not under section 200 of the. The above observation. This criminal petition stands disposed of. You can approach the appropriate forum if so advised to you.
Wait, please, Your Honor.
Yes.
Lordship, the engaged senior counsel is suffering from fever, Your Lordship. Lordship, may I pass over for the matter for today?
This matter since last 2 years, madam. The stay order is operational. The last occasion, hearing almost was completed, madam. We
Yes.
was supposed to pass order.
Yes.
At that moment, time. My festival, this is not a case for prosecution. Because the affair itself, the disclose the commission of offense, and there is also investigation, charge sheet has already been filed. And in fact, the affair lost by him has already submitted final report. In the last 2 years, madam, proceeding has been there.
There is no stay order in force.
Yes, madam, stay order is there.
It's not in force.
Not continued.
After since 14th of August 2023.
Yes, madam, but pursuant to this order, madam, the.
No, there is no stay order in force. Clarify.
Yes, ma'am.
What's your good name?
Jiras, Lordship.
Learned counsel on behalf of Mr. Escalate. For the petition. Also heard Mr. Tohria, right?
Yes, sir.
Law court. I have written PS law court. Learned additional public prosecutor. For the state respondent number 1 and Mr. R. Islam. Learned counsel for the respondent numbers. That's one number 2 will come. That's one number. Is submitted by Mr. Tachin, that counsel for the petitioner. Mr. Escalate. Is unwell. Unwell indisposed. and a space for something. To which the counsel for the respondents have objected. It is to be noted herein that by order dated 14/12/2022, the further proceeding of GR case number 1008/2021, involved in this criminal petition was stayed by the court, and the said interim order was stayed by the court in the interim. The said interim order dated 14/12/2022 was extended by order dated 26/06/2023 till the second week of August 2023. However, it is seen that since 14/08/2023, the interim order dated 14/12/2022 is no longer in force, as there is no such order extending the said interim order dated 14/12/2023. List after 3 extended date to be fixed by the list. Much obligation.
May I please? This revision petition has been filed by challenging the order dated 11/1/2023 passed by the learned principals as forfeiture in FC case number 78, whereby the petitioner has been directed to pay allowance of rupees 4,000 to the Malot. That's one number one, Malot. Interim Malot, judgment is that Malot 28 in SR 5 Malot. Relevant petition, your lordship will find it case Malot 34, the quantum of Malot maintenance amount Malot.
Yes. Where is the illegality in the order?
My lord, I have challenged this order, my lord, merely on basically on two grounds, my lord. My lord, after what happened was after marriage, my lord, the petitioner, my lord, was suffering from neurological problems, my lord. And my lord, she herself, my lord, started to show indifference towards the petitioner. She left the house on her own, my lord. Thereafter, the petitioner served legal notice, my lord. Two legal notices were served to her, my lord, to bring her back. But she did not come back, my lord. After getting, my lord, this legal notice from the petitioner, she has lodged this, my lord.
Have you produced all those legal notice as an exhibit before the learned family court?
My lord,
have you mentioned in your objection?
My lord, it is, my lord, in WS, my lord, it has been mentioned, my lord.
See, in the WS that you have filed, you have not mentioned.
My lord.
So,
but my lord, in my deposition, my lord, I have stated, my lord.
if you do not stay in your objection and make it in your deposition, it will be correct. Can be considered. What is the law? Hmm? You are totally silent in that regard. Tell us why this order is bad, accepting those two. Only ground is that you are suffering and you have issued legal notice. Only those two grounds. Right?
My lord.
What else?
My lord, she has left, my lord, the house of the petitioner, my lord, on her own, my lord. And as per my lord, section, my lord, subsection 4 of section 125.
Did you file any case for restitution of conjugal rights?
No, my lord.
Then
She has.
this is an 125 proceeding.
Well, she has also not filed any criminal case against me.
That's why she asked for maintenance if we did not take her. And all the time, in the meantime, you have married another while existing the first marriage.
That
you
is
have married
much later,
another.
That is much later, my lord.
But see,
Is the
that's
petitioner
the
has been, my
reason
lord.
you are supposed to maintain. And this is 125 proceeding. It's
My lord.
something, as you know, show us any illegality and the order will consider. But otherwise, there is nothing. We have read your reply, your written statement, everything we have seen. And rightly, the learned trial court has, considered, learned magistrate have considered that aspect. The family court has considered that aspect under section 125.
My lord, her basic allegation is that, my lord, the petitioner demanded, my lord, dowry. And
we are not on that. You are against the order of the learned family court granting 4,000 rupees maintenance. Tell us where is the illegality. We are not between the fight between husband and wife. We are on the legality of the order. No ground. Yes. Law court, what do you have to say? Have you read the order? What is your stand as a public prosecutor? Yes. So many judgments by the Honorable Apex Court, our High Court. Why this maintenance to be given and to whom? There's a law has been specifically made by the Honorable Apex. In what circumstance? Okay. Yes, what is your stand? Mr. Razak? Okay. Okay, yes, for the wife, you are standing. Yes, what is your stand? For this order?
He filed the petition on two grounds, my lord. One is medical ground and my lord, one is the wife leave his house to have own. My lord, there is no document on medical certificate, and my lord, medical certificate was not submitted before the family court. And my lord, there is no proof of she left her matrimonial home. My lord, the petitioner could not prove this fact. And my lord, the petitioner performed his secondary study. Till date, no maintenance allowance has been paid to the wife.
Okay. We'll pass order. We know the outcome.
Most of them.
May I please your lordship? Lordship, by this petition, my lord, petitioner has challenged the order dated 3/5/2023 passed by my lord, learned principal just family court, my lord. But my lord, prior to going on to the merit into the case, my lord, may I submit, my lord, today morning I have received instruction that, my lord, they will continue their conjugal right. Only 1 week time may be granted, my lord, to the petitioner, my lord, to settle the matter amicably.
As far as compliance goes, my lord, specific order was there, my lord, on 18th and 23, my lord. Till date, they have not complied with the orders, my lord. Granting 1 week time, absolutely no issue, my lord. Definitely, I'll wait, my lord. As far as compliance part goes, my lord, there are absolutely no compliance. Last part, my lord. No overseas part, my lord. And the maintenance part. Your good name?
S.A.B. Khabir, my lord.
Master S.A.B. Khabir, Planet Counsel for the petitioner. And Mr. P.S. Hariel and Additional Public Prosecutor Assam for the response number 1. Also heard Mr. A.S. Tapadar, Planet Counsel for the response number 2. Matter relates to the order being aggrieved with the order dated 03/05/2023 passed by the learned family court. Borpeta. Passed by the learned principal judge family court Borpeta. In FC within bracket CRL bracket close case number 147/2022. Directing the payment of monthly maintenance of rupees 5,000 to the respondent number 1, I, wife of the petitioner, and rupees 2,500 per month for their minor son. With effect from 29/03/2022. Comma, the petitioner preferred this criminal petition. The court, while issuing notice on 18/10/2023, specifically directed for continuous payment of on 18/10/2023, continuously directed, specifically directed the petitioner for continuous payment of rupees 7,500 to the respondent number 2 for such maintenance, and an amount of rupees 2,500 against the arrear monthly maintenance for the condition that on such compliance, no coercive action shall be taken against the petitioner for non-payment of arrears of monthly maintenance to the respondent number 2. During the deliberation of the matter, Mr. Kabir, learned counsel appearing for the petitioner, submitted that as per instruction of the petitioner, as per instruction, the petitioner is going to take back his wife, the respondent number 2, with their son, so as to maintain the conjugal rights. And for that, the petitioner is seeking a week's time, a week time. On the other hand, Mr. Tobadar, learned counsel for the respondent number 2, submitted that the petitioner did not comply with the order dated 18/10/2023 passed earlier in this proceeding. Till date. List on 7th of August. Failure on the part of the petitioner to do the needful. The court shall consider to pass consequential order, considering the order of the learned principal judge family court dated 03/05/2023, noted above, as well as the order dated 18/10/2023, passed in this proceeding, passed earlier in this proceeding.
Deeply obliged, my lord. Deeply obliged.
16/6/23 judgment is mine. Order dated, my your lord kindly see.
324.
5/3/24, your lord kindly see. In IAM.
I think sufficient time granted to you. See, 5th of March 2024. After the record received by the registry, you took time to submit the objection. The matter was fixed on 18th of March.
It has not listed then
It did
subsequent.
not reach.
Yes.
And then 21st of June. So give us a date by which you will file your objection. Otherwise, we will consider the bail player on the petition and the materials available on record. Give us a date. Don't say within. Say specific date on which you will file your objection.
কোন তারিখ? 24
5th of August.
August.
Okay, let them file on 5th. We'll consider on 3rd, 6th. 6th of August. Heard Mr. H.R. Chaudhary, Learned Senior Counsel. Assisted by
Ardeca.
Learned Counsel for the applicant. Also heard. That's Learned Additional Public Prosecutor. State respondent number 1. The state respondents will file its objection
42 man, item 42.
on or before 05/08/2024. Serving copy of the same in the council for the applicant. List on 6th of August. Consider this application. Failure on the part of the state to file its objection. Court shall consider this application on the basis of the records of the applicant.
Obliged.
Records with trial court.
May please your lordship, this revision has been filed against the order dated 13/7/23, where the learned magistrate rejecting the Zimma prayer of the petitioner, my lordship. In earlier occasion, the honorable court is directed to produce the report of the seized drums. Now 48 drums of suspected crude oil drums, which is lying in the police station. That report has not come as on date.
Board we have not received, but we kindly come to page 24 of the petition. There is already a FSL report in there. And it is a fail always. That two questions should put as per order dated 12/9/23 by the honorable, by his honorable court. 12/9/23.
Yes, please come to paragraph 8 of the petition, revision petition, page 7. Read para 8. What is your stand? You have also pointed out page 24. You have read. Now, what is your stand? To be an essential commodity, what it should be?
If it is essential commodity, then on one more thing also that they have to purchase it also. But as per report, page page 41, can become also. Ownership of 41 also. Second, ownership of 48 numbers of drums containing fuel oil would not be ascertained as to whether GST receipt provided by the accused party are found to be invalid receipt. As per the report received from the Assistant Commission Seal Tax Receipt Cycle, so, whose GST has been cancelled since so. So, Lordship, whether they are the it is they are the authority. It is whether they have purchased it not Lordship. It is not a certain Lordship. That could not be a certain Lordship. So if it is not, it could not be a certain Lordship, then and if it is a fuel Lordship, then it is a dangerous for public Lordship. They cannot produce the houses and all Lordship, then all with the illegally procured Lordship. And as such, Lordship is 40 last week Lordship. Therefore, has directed the I would also to initiate the confiscation proceeding. But whether it is that proceeding was initiated or not, also that I could not answer.
এই গ্রামটিতে সলিসিট পিছনে কাছে যে এটি এখানে এটি ডেঞ্জারাস হতে পারে নাকি রাস্তা দিক দিয়ে নাকি এখানে রিপোর্ট করতে
Yes, tell us, madam, by which you can show that you are the owner of those seized oil. By which particular proof you were able to establish that the seized oil, whether it is fuel oil, whether it is crude oil, whatever, belongs to you? Because the GSTIN number is not in force since 2021.
But if you annexer 5, page number 33, the petitioner filed the petition praying for Zimma 48 numbers of
Yes, Zimma to whom? The concerned owner.
Yeah,
How you have proved that you are the owner of that one? Where is that proof?
I'll just search it.
Because the document that you have placed is without any force because it doesn't have any GSTIN since 2021, which you have not denied.
Yes.
Where is that document by which you have purchased?
I has submitted such sheet, my lordship. Actually,
You are asking for Zimma on what basis?
Tax invoice against MS Jagadish Prasad for GST. Actually, Sham Enterprise has taken business in the name of Jagadish Prasad Shah. GST is in his name, my lordship.
But this particular form doesn't have the validity since 2021. It's very clear. So,
Page number 36 down below, my lordship, down below. In this regard, MS Jagadish Prasad Shah, whose GST number has cancelled since IOH says one agreement between Pankaj Chaudhary and Dayanidan Gupta from.
you are not on that.
36,
Where is the receipt?
36, page number down below. After get the evidence, IO arrested. Huh? This is the my lordship, this is
Where is the tax invoice?
burnt oil. Tax invoice, I'm not enclosed. Tax invoice we have already.
So, you relied on that.
Tax invoice already.
You relied on that, you purchased, that is why you are having the invoice.
Already police says.
Say
them.
48 grams of oils. Where is the seizure list?
Seizure list is number 17, my lordship, page number.
17.
Type copy is 17, my lordship, original.
There is no such tax invoice in the seizure. Article says it 1/6 wheel truck and 48 drums.
Actually, this is the burnt oil, my lordship.
So how you are claiming, on what basis?
Yes, sir.
Now the FSL report is very clear, it's a fuel oil. It cannot be burnt oil. First of all, to have the Zimma, you must have the proper authority, right? Where is that?
Minus, page number 39. In the report is mentioned that exhibit C, 1/16/20 gave positive test for fuel oil. The density and flash point of the exhibit is found to be 0.82.
We are not on that. You are asking for Zimma, it was rejected, against which you have filed this revision petition. Where is your authority with regard to those 48 grams of oil? Unless you have proper and valid authority to have those crude oil, fuel oil, as per the report, it is fuel oil. As per the claim by police, it is crude oil. We are not on that. First of all, you must have the authority to have it. Where is that? We'll dismiss it.
Then pass over the matter.
No for Passover. We have heard you sufficiently.
Then after some time, my
No,
lord.
no, no, nothing like that.
After some time, my
Question of after some time will not come. If you have, since you have failed to establish your authority of those 48 grams of oil, why should you have this petition? And further all this, there is a stay order in force. Not considered.
Stay order, there is no stay order. Any stay order?
Third, MSR Begum, counsel appearing for the petitioner. And Mr. Surreal and additional public prosecutor for the state. During a NACA checking at night on 01/08/2022, police personnel from Gaurisagar Police Station at Gaurisagar Bazar Tiniali after a huge chase could intervene one Tata 1109 vehicle with registration number UP 32-QN-7217 that came from Sipsagar side towards Jorhat to National Highway 37, which did not stop in spite of signaling. And recovered 48 numbers of drums containing suspected crude oil. The driver of the vehicle, handyman of the said vehicle, and those 48 drums suspected to be crude oil was accordingly seized. Both the driver and handyman of the vehicle also were taken into custody. The police personnel considered involved in NACA checking and seizing the vehicle and the 48 grams of crude oil. Considered those oil to be essential, stolen essential commodities, stolen to be stolen crude oil, being essential commodities, transported illegally to different parts of the state and the country. In that regard, an FIR was lodged before the Gorisagar police station. It was registered Gorisagar PS case number 90/2022 under section 120 within bracket B/379/411/353 IPC reviewed section 7 of the Essential Commodities Act 2010. After investigation of the case, police submitted the search sheet in said Gorisagar PS case number 90/2022 on 24/05/2023 by charge sheet number 15. Against the driver of the vehicle, the handyman of the vehicle, and 3 other persons, including the petitioner and the owner of one Messrs Shyam Enterprise under section 120B/379/411/353 IPC, reviewed section 7 of the Essential Commodities. The FSL report dated 28/09/2022 with regard to the contents of the suspected crude oil in those 48 drums seized in said Gauripur, PS case number 90 of such and such. Specified that the said seized oil gave positive taste for fuel oil. The petitioner filed a petition being number 184/2023 before the learned judicial magistrate first class Sibsagar for Zimma of oil found in those 48 drums seized by police in connection with said Gauripur, PS case number 90/2022 seized on corresponding to tier number Gauripur corresponding to tier number 578/2022. Put in bracket PRC case number 111/2022. Seized on 01/08/2020. Learned additional chief judicial magistrate Chief Sagar. Inside Zimma petition of the petitioner 184/2023. White order is 26052023. Call for the report from the concerned investigating officer of Gauri Sagar PCS case number 90/2022. Pertaining to that's Roman 1. Ascertainment of ownership of said 48 numbers of drums containing oils, public burns mobile, industrial lubricants, public oily sludge, etc. And whether those 48 numbers of drums containing such oil are required further for purpose of investigation. Pursuant to the same, the authorities of the Gaurisagar police station approached the Assistant Commissioner of Taxes Sibsagar unit stating that during investigation of the case, two number of tax invoice was found that was generated against the recipient Messrs. Jagadish Prasad Shah. Page number 25 of Silver. Within the GST name, amounting to rupees and rupees Iman. Though no such e-way bill was found to be generated It's found liquidated. Liquidation of seeking report will liquidate. The officer in charge of Gori Police Station approached the Assistant Commissioner of Taxes, Sipsagar unit, seeking report on 2 numbers of tax invoices. That found in the investigation. The Office of the Assistant Commissioner of State Tax, Sipsagar, by its communication number SIB oblique 2022-23 oblique 421 dated 16/08/2022, informed the officer in charge of Gorisagar Police Station that the said office who detected no way bill material and no such way bill was found to be generated by Prem Darshan Singh, proprietor of Messrs. Syam Enterprise, within bracket GST number 50, specifying that Messrs. Syam Enterprise prices bracket GST had issued tax invoices against Messrs. Jagadish Prasad Shah for about Markpuri whose GSTN had been cancelled since 2021. Observing that the such process indicates evasion of tax. After obtaining such report, as well as the FSL report dated 28/09/2022, the officer in charge submitted its report before the Gorisagar Procedural. Submitted his report before the Additional Chief Judicial Magistrate Sipsagar on 31/05/2023. Specifying that the ownership of 48 numbers of drums containing fuel oil could not be ascertained, as whatever GST receipt provided by the accused party are found to be invalid receipt. Since the report of the Assistant Commissioner of Sales Taxes Sipsagar clearly indicates that Mrs. Jagadish Prasad Shah, which is the GST number to page number 41. The GS Shah indicating that the GST number of such and such and such issued in favor of Mrs. Jagadish Prasad Shah was cancelled way back in 2021, and that seized oil are not required for any further investigation. The scientific officer pursuant to the letter of the Superintendent Police Sipsagar, dated 10/02/2023, with regard to the FSL report dated 28/09/2022 noted above, I regarding clarification of fuel oil. The clarification regarding the seized oil to be fuel oil. The scientific officer of the Directorate of Forensics of Assam on 04/04/2023 specified that considering the density and flash point of the said seized oil considering it density and stress point, and as per the Bureau of Indian Standards, within bracket BIS, bracket close specifications IS 1593, the said seized oil seized in the Gorisagar PS case number such and such, found to be a category of fuel oil / furnace oil. In the said report of the scientific officer, Director of Forensic Science Assam, was forwarded to the Superintendent Police Sipsagar by the Director of Forensic Science Assam, by communication dated 05/04/2023. The learned JMF Sipsagar considering the fact that the petitioner who claimed Zimma of the seized oil in 48 grams seized on succession's death in Gorisagar PS case number 7 to be the valid owner of the same, rejected the said claim of the petitioner by order dated 13/07/2023. Even in this petition, the petitioner could not place any valid document to be the owner of those 48 grams of oil seized by Gorisagar police on the night of such and such from the said truck such and such in connection with Gorisagar PS case number such and such. The petitioner by all means failed to prove and establish that the 48 grams of 48 grams of oil seized in connection such and such on such and such date belongs to him, who did not find any such illegality or immunity in such order dated 13/07/2023 passed by learned JMF Sipsagar, rejecting the Zimma petition of the petitioner number 1/24/2023 with regard to the said 48 grams of oil. Accordingly, this revision petition being without merit stands dismissed. The interim order passed earlier on 22/08/2022, it's accordingly stands vacant. Registry shall forfeit communicate this order to the Court of London Judicial Magistrate First Class Sibsagar, as well as the Court of London Additional Chief Judicial Magistrate Sibsagar.
May I please, Lordship? My lord, to substantiate my stand, my lord, I relied upon some decision that has been submitted before.
Mr. Mahajan, you're supposed to play something, right?
Yes, my lord. It is not barred by limitation, my lord. I have to make the calculation. The relevant provisions are 138B, 138C, and 142B, my lord. The only delay is 1 day delay in sending that notice, my lord.
So there is no delay.
There is no delay, my lord. I can place the dates before my lordship. My lord. Yeah, my lord.
Okay.
But the check was returned as not paid, my lord, on 4/8/21. And the notice was sent on 3/9/21. That is after 31 days. There is a 1 day delay in that, my lord, but that is covered by the Supreme Court, my lord. That limitation period, my lord, was excluded.
But there is judgment. Okay. After the 31
Yes, that is
days.
covered that. Then, my lord, the notice was delivered on 29/9/21. And payment was not made in 15 days. Now, the 15-day period is 13/10/21. So I have to file the case from 13/10/21 within 30 days. Now I filed the case on 11/11/21, my lord. That is within 30 days, my lord. It is within exactly 30 on the 38th day of the date of the cause arises, my lord. So there is no delay, my lord. And subsequently, my lord, the Honorable Supreme Court has also extended that period of limitation, my lord.
And that is covered, my lord. That is, I am not disputing.
So,
my
Mr.
lord.
Bhuiyan, your ground
Now, my lord, so far my
for this
submission,
criminal petition.
my submission is concerned, my lord, I challenge the complaint as well as my lord, impugns order of summon, my lord. The summoning order also challenged, that is not.
Why? What is the reason? What are the grounds for challenging it?
That is, my lord, my lord, summoning order not proper. Without application of mine and my lord, with general observation, this summoning order passed, my lord. And
See,
two case file, my lord. Two case file on the same day, having check number different, one more than 48 lakh, another 1 crore 60 lakh. My lord, but this order found similar order. That is, my lord, general observation. And there is nothing, my lord, without application of mine. Therefore, my lord, I challenge this impugn order.
Is it required that the London magistrate should record all this in his order?
My lord,
It's sufficient on the basis of material safety.
in this
London
aspect,
magistrate
my lord,
comes to that,
in this
you
aspect, my
can
lord,
take the cognizance. Why not?
my lord, in this aspect, I relied upon my lord Pepsi Food Limited, my lord,
Hmm.
and versus special judicial magistrate, my lord. Here, my lord, the Honorable Supreme Court observed, my lord.
Give us the citation.
Yes, I have given the citation, my lord. 1998. I have submitted my list of citation, my lord.
Maybe there. Just a minute.
Because this summoning order, my lord, with general, my lord, observation, my lord. Generalized observation. And here, my lord, para 28, I relied upon.
Just a minute.
Para 20. May I read, my lord?
Just a minute.
the magistrate has to carefully scrutinize the evidence brought on record and may even himself put questions to the complainant and his witnesses to elicit answer to find out the truthfulness of the allegations or otherwise, and then examine if any offense is prima facie committed by all or any of the accused. That has not been done. Because one check consisting, my lord, rupees 48,91,000, and another check, my lord, that is consisting, my lord, amount 1,60,78,000. But in both the summoning order, there is no such indication regarding the check and date of bounce of the check. And for just routine manner, the summoning order passed.
Okay.
Now, my lord, this, my lord, one of the leading judgment. Recently,
the
my lord,
order?
Honorable Delhi High
Where
Court.
is the order?
Lordship,
Page 49.
Case 49. Case 49. my lord. So this order does not reflect, my lord, the application of mine as decided in Pepsi Food Limited. At least reflect application of mine by the land magistrate. This is the common order, my lord. Usual manner. What is the amount, check date, and when bounds, nothing is there. And my lord, in second application,
The
it's
judgment
same order.
of the apex court. Let me find out. Now, regarding taking cognizance of an offense, in a complaint petition. Now, Pepsi case placed by Mr. Bhuya. He's on it.
But party paramount.
We have seen that discretionary. We have seen that. Now, the Honorable Apex Court, their lordship in that judgment have specifically mentioned that cognizance to be taken by the magistrate and issuing someone because no doubt issuing any criminal proceeding against a person. But 482 petition was filed taking cognizance against the accused person. There under the Apex Court specified what would be sufficient in taking cognizance.
Not the 50. My lord, not the 50 order. Third,
What would be sufficient in taking cognizance? Because cognizance means at least the magistrate has to exercise his judicious mind.
No,
Right? There is
Senior
it is very specific.
petitioner, my lord. First on the point of maintainability, my lord. This is the second petition on the fourth. All these points were raised in the first petition as well.
Then it was withdrawn, I believe.
It was withdrawn without any liberty, my lord. And the Supreme
Without
Court-
liberty.
And the Supreme Court and Visham Lal, my lord, placed.
No, Bisham Lal not covered in this case. Bisham Lal, my lord, first application was,
Also similar-
there was my lord finding. And so far my withdrawal, that the Honorable Court, there is no finding. And there is no direction. And so far Bisham Lal case is concerned, my friend submitting again and again. And there was direction to the petitioner to approach before the trial court. And by not complying, again approach before the court, High Court, and file subsequent application. That therefore not maintainable. But my case is quite different proposition. Initially, this withdraw, at the very initial stage, it was withdraw, and notice was just issued, but no step was taken, and other side also not entered their appearance. And by filing my mention memo with the due permission, my lord, then withdraw, my lord. And the Honorable Court says that at criminal matter, the initial stage, liberty not necessary. In Bishamlal case is quite different. There was a finding and was a direction given. Now, my lord, in this aspect, my lord, one of the Supreme Court has given a guideline how to take cognizance. And in this aspect, my lord, I relied upon one decision, my lord. That is, I have given the citation in my lord, India Bank Association versus Union of India.
First of all, you have to overcome the hurdle
Lordship.
that filing second petition without taking leave.
No, my lord, Bishamlal case, my lord, kindly have a look, my lord. Bishamlal case saying,
Who is
initially,
appearing
my
is-
lord,
John, are you appearing in this matter?
that matter just withdrawn at the initial stage, and this honorable court has not attained any finality. And when it not attain any finality, and there is no any direction, then subsequently another application under section 482, there is no bar. And Bishamlal case also saying that when separate different pair, then there is no bar. Bishamlal case. And my lord, Anil Khandi Dewala case, my lord, I have already submitted this citation, 2019 7 SCC
Just a minute.
294.
Just note down.
Bishamlal. Lordship, in Bishamlal case, there are 9, last 2 lines, my lordship. As the High Court did not have the power to upset the order dated so and so, which had attained finality.
Bishamlal's case.
Which attained finality. But so far my case is concerned, it was withdrawn by submitting mentioned memo at the very initial stage. And other side was not enter appearance. Very initial, without any finding. So it is maintainable. And so far, my lord,
Again, I have time.
Come back to you.
And Lordship, even first application dismissed, and second application under section 482 is maintainable if there is a different prayer. And ground also some different, then it is maintainable. The three-judge bench, Lordship, in Vinod Kumar case, my lord, saying that dismissal of an earlier petition under section 482 CrPC would not bar filing of subsequent petition. In Vishamlal case, it is very clearly mentioned. Paragraph 8.
Yes, which law, which particular case are you relying upon? Mr. Bhuya,
Lordship,
which particular case?
Lordship, in my lord Anil Khandewala case, I have submitted this judgment 2019 17 SCC 294 para 8. Para 8. It is held that a successive application under section 482 CrPC under same circumstances was maintainable and the dismissal of the earlier application was no bar to the same. But my application was not dismissed, withdrawn, and my here, my lord, new second application, there was a prayer also different, my lord, not same. And some ground also added. My lord. So this Mohan Singh case is covered, my lord. Because summoning order in the second application, my lord, challenge, my lord. Because which has not covered, my lord, so far this Pepsi Food Limited and Agat. It's a very one of the leading judgment, my lord. And recently, my lord, the Honorable Delhi High Court also followed this judgment, Pepsi Food Limited, in regard of quashing of complaint under section 138. And saying that the judicial magistrate cannot generalized observation made in routine manner. Justice side and deed is found different. Even, my lord, in bail matter, when first bail application rejected by the court, again subsequently on new ground can file liberty not necessary. In mention memo, I have clearly narrated, my lord, the liberty is to be given, but court saying that as it is very initial stage, So liberty not necessary. It was withdrawn by your mentioned memo. Mention memo. Mention memo উল্লেখ আছে। আবশ্যক নাই। হয়, that's it. And Lordship, in the first application, 173, dated 27/3/2023, office note reflected that one withdrawal form was submitted. And in withdrawal form, it was very specifically mentioned, due to technical defect, allowed to file second application, liberty. Court saying no, this initial step, why liberty is necessary?
Yes, Ms. Jahan. See, the law is settled that with regard to any petition, it is withdrawn, particularly in criminal prosecution. When it is a application preferred under the 480. In case of chance circumstances, yes. Second criminal petition possible. Here is a case for the same ground, same often, same thing. Though 483 petition was filed, it was withdrawn. And is the petition was withdrawn by the accused. That too, the order was first dismissed, there was no liberty. Whether the same person can prefer, there is no sense circumstances in the present case. Whether this particular petition will be maintained.
One Gujarat High Court judgment I got where it is said which is maintainable. If had the first 482 petition been dismissed on merit, after hearing the entire case, okay, second 482 will not be maintainable. But in case it is withdrawn, withdraw without liberty, that makes a problem rather. But then in that Gujarat High Court case, it is said that with liberty was not pressed upon, and it is said if had it been withdrawn simply, then the second would be maintainable. Had it been withdrawn on merits, or had it been heard and disposed on merit?
No, whether that is the thing, see what order was passed.
What order? What is facts and circumstances? That is not spelled out in any of these judgments.
So, what was the order passed in the earlier case? Because record is before us.
No liberty was taken.
Yes. Only withdrawn.
But it's a one-line order.
Yes.
If we are
At
11% submit
initial stage.
instruction to withdraw.
Yeah, initial stage.
Yes. According to as prayed for this criminal petition stands.
We-
disposed.
we-
See,
with a
it is
withdrawal
not a
form.
case that the very first day the petition was withdrawn. The court, at the first instance, issued notice.
Yes.
Same thing, cognizance, right? Court issued notice. On the next day, that means court exercises judicious mind while issuing notice. Rightly. Then, on the second day, it was withdrawn. The High Court only issued notice. Because on the basis of the materials available, that means what? After the petitioner was heard,
But Lordship, in this case.
now the second day petition was withdrawn by the petitioner. Now he can again prefer a petition or not.
My lord, here is
It
same
is not a
circum.
case where the petition was filed and before any order was passed, it was withdrawn. It is a case where the petition was filed, court heard the matter, and then issued notice, and thereafter it was withdrawn.
Some differences there.
That
But-
means,
But here, my
what
lord,
about the Gujarat case is that withdrawn? So nothing was on merit, but here was a merit, court issued notice thereafter.
And this case of Supreme Court has my
is Binod Kumar case. 3 judge bench case, my lord. 3 judge bench case saying if dismissal on earlier petition, even second application is not
When
passed.
there is a sense circumstance.
But here also, my lord, there is change circumstances, my lord.
There you will see it's
My
possible.
lord, my lord, question is, my lord,
Possible.
whether my
It is a
prayer
case
is,
where with regard to the notice was issued with regard to an NIT case. He was the manager, he resigned. Right? So the 482 petition was because he did not, he resigned, so no case can proceed against him. That is what has been to spot. Thereafter, another 482 petition. was. So the court found it is entirely changed circumstances. In that sense, circumstances definitely.
Oh, change of.
but here, my lord, new
Here,
case, my lord.
Here, the petitioner is pressing all these things. It is a case where the court, after hearing the petition, issued notice. Thereafter, he chooses to prefer withdraw. It is his motive. The law equivalence will come here.
My
You
lord,
cannot simply detach away from the law of equivalence. In that case, what will happen? Every time person will withdraw and will come able to second time. That is,
what is written in this judgment.
that is,
will come and-
exactly, that is not the case here. In
But-
that case, what will happen?
but here, lordship, this present case, my lord, kindly have a look for a moment.
No.
First application, there is a prayer. But here, my lord, in new prayer, the impugn, my lord, summoning order also challenged.
Prayer may be, because see, prayer may be different. Where is the change circumstances? Circumstances is not the prayer because it was the earlier incident which you have not brought to the notice of the court earlier in the petition.
We should know what the requirement is that those facts should be known
In
to
there.
him before the first application.
Simple
was
reason that inadvertently something could not be placed.
That
So maybe withdrawn and to file afresh. Because it is a fact that that particular point was not raised in that petition.
And moreover, there is mandatory whether it was written about his first application in this one.
I think it is mentioned somewhere. I earlier occasion, I think I read somewhere. It was that there was a mention probably there was a mention. Somewhere para 10 or something earlier I had gone through.
Because lordship, here, my lord, in this present case, my new ground added. With regard of the decision of Honorable Supreme Court, I have mentioned, my lord, under ground number 8, this was not available in the first application. And I relied on the G. Pankaj Jaskashi Amma and others case, my lord, relied upon. And this was, my lord, this is when I come to know that this is very much important to be a ground and added ground. Therefore, my lord, I add and subsequently filed. And this prayer also found different. Earlier prayer, my lord, only proceeding, criminal proceeding. But here, my lord, impugn summoning order challenge. And lordship, and the ground number 10 was not challenged, this new ground. That is the land court below proceed the case by passing an impugn order dated so-and-so without taking cognizance of offense against the petitioner, hence the impugn order dated is also deserved to be set aside and quashed. So, my lord, if I rely on this particular one ground. If I rely this particular one ground, then maintainable, my lord. Other ground not trace, my lord. If not trace other ground, then this only one ground I can trace. This is a new ground. There is no bar that I cannot challenge before the court by challenging new ground. Because earlier case, notice issue, that doesn't mean that the oral court attain the finality. This is the usual process. Initially, notice issue. But no finding was there. Without hard other side, how the court can come to conclusion? There was no conclusion. But this Bhimsham case, there is a conclusion, there was a direction to appear the petitioner before the trial court. But he did not comply. And without complying, he again approached before this court by filing subsequent application under section 482. Therefore, the court says, rightly says, that why you come again? Not by not complying the first application and order. But my case not covered in this case. Quite different proposition.
The new ground, new prayer. Change in prayer will not suffice here because.
It was already there. It was inadvertently the petitioner did not present his earlier petition. Now he wants to incorporate this. So he is saying that's a new ground. It is not that it was not there earlier.
The question, my lord, by ratio, if not liberty, even though today I can take liberty to file a fresh case.
Okay.
Madam,
Mr.
earlier not liberty,
Mr. Bhuiyan.
today also can take
Do one
liberty to file fresh.
We'll hear it on Tuesday. You're having time? Go to the judgment passed by Honorable Three Judges of the Apex Court.
That, Kumar.
2005 at 8 SCC 89. 89. SMS pharmaceuticals versus Nita Bhalla.
Nita Bhalla, yes.
Go through it. Where the taking of cognizance in NIT case. Sufficiently. When reached. And also tell us, since the liberty was not taken, whether this 482 petition second time will be maintained.
Otherwise it's always there in such cases, but again.
See, liberty is there because in certain cases, what happened, certain petitions were withdrawn without liberty. Then the Apex Court judgment have clarified, because the matter went up to the level of Apex Court, their Apex Court clarified that regarding the withdrawal petition doesn't amount that the petitioner has given the liberty regarding his fundamental right to be withdrawn. So it will be always there. So he can always approach, even the liberty was not obtained in the withdrawal of the petition earlier. Right. So in that context, the Apex Court has said that. So matters in relating to service law, relating to some promotion or something, if somebody has given withdrawal without liberty, it will be considered. But if somebody is illegally appointed, that illegality will remain. So in that case, he always can approach the court again. The question whether he has taken liberty or not will not be there.
Right.
That's where the differentiated the court.
And
thing is this
so
here
far,
also.
So far, my lord, criminal jurisdiction is concerned, everyone has liberty. Ultimate
Because
liberty to
there
file.
is a case where the court, after considering the matter, hearing the petitioner, has issued notice. Hereafter, the petitioner has withdrawn. So what will happen?
But that doesn't mean that there was a finding. What side was not heard? The initial stage. Usual process, usual manner, my lord, notice issue.
Definitely will consider.
Usual manner, my lord, notice
We are
issue.
not passing any order today.
But no finding, there was no direction, my lord.
See to that.
But so far,
We have
not
it on Tuesday.
Bhimsham
Mr. Mahajan,
Lal cases, there was a finding. Direction was given
We'll go
to
through it.
approach before the trial court. But here, my lord, no direction was given. Not disposed of. Bhimsham case was disposed of, earlier one, with a direction. And that is a finding. That is called finding, my lord.
We'll
But
have it
so
on
far,
Tuesday.
my case is concerned, no finding was there, that NGO was not disposed of.
No, what would be required would be a new ground, not a new ground per se, but then same circumstance,
Same circumstances is already explained by the Honorable Apex Court.
change circumstance.
Our High Court judgment is also there. What is same circumstances? Justice Kotuki's judgment is there, another judgment.
Second application, there is a stay, my lord. That shall be
Tuesday,
considered.
Tuesday.
That shall be called recorded.
There is also a stay.
And Honorable Supreme Court recently says that if one stay, then it will be continued.
Please, Lordship. In item 16, Lordship, my lord, this is an application for my lord cancellation of bail, Lordship. In a very unfortunate, my lord, case, Lordship, my lord, my lord, unfortunate, my lord, there is a fracture, my lord, and miscarriage, my lord, because of my lord torture caused by the respondents, Lordship. So in that case, my lord, they were granted bail by the learned court below, Lordship. Probably because of my lord, lapses on the part of my lord, there may be malafide, my lord, of the investigating officer, Lordship. Now, my lord, the charge sheet is also, my lord, filed, Lordship, submitted. My lord, case was registered, my lord, under section.
Where is the order?
My lord, the order is at page 22, Lordship. Page 22. Sorry, Lordship, page 23, Lordship. This is, first one is interim bail, Lordship. Page 22 is interim bail. Second is, my lord, 23, this is final bail, Lordship. There is no ground, my lord, assigned in this order, Lordship. Only because, my lord, interim was granted, Lordship.
What is the report of the IO?
My lord, IO report, it is not there, my lord.
Yes, not required. Come to a page number 23. No, no, the finding is there. No, fine. The read call for CD. The calls for CD has been received. From there you start.
I've gone through the CV as well as the material.
The previous paragraph.
Because I submitted in the accused local. If further submitted the accused persons are innocent and they have been falsely imputed. As paid to make absolutely earlier order of pre-arrest. And CD was gone through and then he appeared before the IO, considering none of the opinion custody injury not required.
Can it be a ground for cancellation of the bail?
Cancellation
How
of
can-
bail is okay.
Only if now the submission of Mr. Ali is that since the court have considered that the petitioners were earlier on previous bail, the accused persons were an earlier bail, so that is not the case.
On some subsequent violation of conditions.
No, here also the court found, considered the material in the CD.
And
If they are appearing before the IO,
statement was recorded.
then question of custodial interrogation not required. That's what the finding.
My lord, now at this stage, my lord, charge sheet is also already, my lord, submitted, Lordship.
So,
my lord,
if the
you
charge sheet
Lordship,
has been submitted, then
for a
what is-
moment, Lord, kindly see the charge sheet. My lord, what is, my lord, what is going on, Lordship, kindly see the
That
charge
is
sheet.
not be-
Lordship. What is going on, my lord, in the department of in the police department, Lordship.
Paragraph 6, that after the bail was granted, they are pressurizing the
Yes,
petitioners, people.
that was there.
different action, cause of action.
My lord, the investigation was frustrated, Lordship. I was, my lord, I was pressurized, written, Lordship.
Have
So
you
that-
filed a second FIR?
Second affair, this is.
Have you filed against this?
That is not an act, Lordship. That was second affair was also, my lord, lost. My lord, by order dated 30/8/2023, Lordship, kindly see.
Second FIR was lodged on 28/4/2023. That was also called for by order dated 30/8/2023. Even the charge sheet is filed, lordship, my lord, the petitioner is not safe to, my lord, adduce evidence, lordship. Under such circumstances. Hmm? My lord, this is the copy of the second FIR, lordship. It was also called for, lordship. The if this is the conduct of the accused, lordship, then how the fair trial will be possible? Hmm? No.
Who were arrested?
My lord, arrested, lordship, one is a on bail, my lord. No, nobody was arrested, lordship. Nobody was arrested. My lord, on bail, lordship, that 3 persons were on bail. This is Farooq Ahmed, Rashid Ahmed, and Gulshan Begum, lordship. These 3 persons have been sent up for trial, lordship. The main other accused have not been sent. Some witnesses have been sent for my lord, trial, lordship. Some witnesses, kindly see, my lord, in the, my lord, this name, my lord, the charge sheet, lordship. Some witnesses, my lord, this is Geeta Devi, Sabita Devi, Biha Kumari, Mamsa Devi. Well, those persons were, my lord, present during the, my lord, occurrence, lordship. They were, my lord, sent up for trial, lordship, as, my lord, accused. This is happening, lordship. And the IU has protected the accused, lordship, so that the petitioner cannot, my lord, get justice. They will definitely, my lord, acquitted. They were not, they were not, my lord, accused. They are not in. They were witnesses in this case. They were met by, my lord, accused, and the charge sheet is against them, my lord, submitted against them, lordship. Hmm?
There are no few of them are not accused. They are discharged.
What is there in the, my lord? I don't know.
No, charge sheet to 2-3 nidile, no. They are discharged.
Our section is 323. Extra is a medical college of report.
Farooq Ahmed, Rashid Ahmed, Aru Gulshan Begum. Geeta Devi was not there.
No, again, husband, charge sheet has been filed.
Yes, lordship, against only husband, lordship.
But other
Torture was, my lord, torture was done collectively, my lord, by the all the 3 persons, lord. My lord, kindly see the medical report of Sinsor Medical College, lordship, and hospital, lordship. My lord, this is specific fracture is there, lordship. How the 323, my lord, charge sheet is submitted, lordship? And in that case, how the petitioner will get justice, lordship? In this charge sheet, my lord, very clearly there the probable is, my lord, there is simple injury. Now, probably, my lord, how can say I that probably simple injury? Is it, lordship, in my humble submission, it's charge sheet, lordship?
Lord, he has not come against the charge sheet. What he wants is cancellation of
Submitting, my
bail.
lord.
Uh-huh.
Appearance on how, my lord, the file will be.
No,
File will be.
cancellation,
Fair, lord.
lordship.
There's an order from the court on 30th of August 2023. As to whether an FIR was lodged by the petitioner against her husband and other two persons. Now, that was filed on 28/04/2023. Time was granted to the officer in charge of Lakshmipur Police Station to apprise the court. We do not know. Right? Though this matter is a second way, will not interfere because such it has already been filed. So, happened. The thing is this, whether the second FIR lodged by the petitioner has been registered or not, because the Lalita Kumari is very clear. Once an FIR has been lost, it has to be registered. So get the information whether it's been registered and what is the status of it.
Lordship, I can bring that.
But this petition, because in the meanwhile, the charge sheet has been filed.
Well, charge sheet has been, now appearance on, my lord, there will be no fair trial, my lord. Well, if during investigation, after getting bail, my
One of
lord.
the petitioner has already been charge sheeted accused, not only the FIR, charge sheeted accused, already his brother-in-law and sister has been linked. Pursuant to the order of the court dated 30/08/2023. On the next date fixed, the officer in charge of Lakshmipur Police Station, Kachar, shall apprise the court of the FIR dated 28/04/2023 lodged by the petitioner against the FIR name accused persons, namely Farooq Ahmed, Y.M. Rafiq Ahmed Chaudhary, and Rashid Ahmed, all sons of late Maulvi Hamid Raja, of Sapor Moina, SAPAR, MOINA. Part 3, Sapor Moina, part 3.
It is second.
Police Station, Lakshmipur,
Oh,
the present status
item?
of the same case.
No.
Police found item
16 now. Where is it?
22nd of August.
Sorry, if I cannot.
Copy of this order be furnished to MS as the hunt for unnecessary uses. Rest, as you know.
Lordship.
Cancellation is not made out.
Yes, lordship. Just a minute. It is to be noted.
But I am appearing for the private.
Just a minute. We'll take it, Mr. Azad. That during pendency of this petition,
I have a disagree.
the
It আমার নাই charge sheet. Isn't it? It was for even now.
Lakshmipur Police Station. Now, the investigating officer of Lakshmipur Police Station, case number 56 of the 2023. Corresponding to PRC number 271 of the 2023. Submitted charge sheet on 31/05/2023. By charge sheet number 101 of the 2023. Against the respondent number 1. Sorry, respondent number 2.
I hate to use those in my cupboard. Dia boleh kata, procedural cover. One second, if I can. Receipt.
Petition number 3, respondent number
Right, to
2,
28
respondent number 3. Respondent number
23. 23
6.
yeah. 23 red one. Okay,
And did not forward the name of
24.
names of.
By Rehana Begum Chaudhary.
Respondent number 4, 5 and 7. For trial due to insufficient evidence. The petitioner touched it under section 120B, 498A, 341, 323, 509 IPC. IPC. See. Against respondent numbers 2 and 3. And under section 120. B 341, 323, 509. No, no. Yes, sir. Hardware packet लिखे दो. Submit for the petition. Some Jahan for public pursuit for 1 and AK Ajad Land Council for the corresponding numbers 227. Okay. Take that. The copy of this order to be furnished. Okay. Take a deal. Yes, Ms. Jahan on 22nd of August.
Not, I'll get them.
Yes, status of the.
Your Lordship, this Madam Mayor pass about the day, Your Lordship. Your Lordship, Mr. Council, Lemons also have to leave this court for attorney and Jana Your Lordship. One of his relative expired today.
Next item.
And Mr. S. Roy, counsel appearing for the petitioner. MMS R. Chaudhary. Learned counsel. For the respondent number 2. Also, have Mr. A. Roysel and additional public prosecutor for the respondent number. Registered in the records of criminal revision case number 38/2021 from the court of London. Session Judge Karimganj. Call for the records of Miss case number 763, sorry, Miss case number 617/2018 from the court of London. Chief Judicial Magistrate Karimganj.
Lordship, on that. It's my lordship, this is a second revision. Husband already filed a revision before the district judge, lordship. So this is the second revision. 482 was incorporated, lordship, for quashing of the judgment, lordship.
That we have seen.
Lordship. So, and he is not paying to the wife also.
Let the record from the London Chief Judicial Magistrate come.
Lordship.
Consider.
And the ADR amount also, lordship.
Ms. Chaudhary, counsel appearing for the respondent number 2 submitted. That the petitioner. I, her husband, has not paid any fee towards maintenance, towards her maintenance.
Not paying regularly, lordship.
Not paying the maintenance regularly for her maintenance has been directed by the London Chief Judicial Magistrate Karimganj and upheld by the Honorable Session Judge Karimganj.
Lordship.
Not the list.
Applies.
30th of August. Yes.
Your Honor, this is the judiciary jail appeal, Your Honor, convicting the accused on the section 3 of the civil. For 7 years,
You are appearing as
legal aid counsel.
Have you filed any objection, Mr. Busher, regarding the bail petition?
Lordship, it is below 10 years, Lordship.
No, you are not filing. Okay.
7 years. No,
7 years. 7 years. I'll be fine for the display. I said 80 mention of China. I would said that display that legal counsel. Okay, I do for it. I think
Thank you.
The appellant hearing. The Learned Session Judge Kasar Silsher. By judgment and order dated 19/01/2024. Passed in sessions case number 84/2018. Convicted. The accused appellant. Under section 326 IPC. Sentencing him to rigorous imprisonment for 7 years with fine of ₹5,000 in default of payment of in default, simply in prison for 3 months. Hence this appeal from jail by the appellant. Ms. Sangeeta Khataniya, learned legal aid counsel, represents the appellant. They prefer it appeal, this statutory appeal, appointed, because this appeal be admitted for hearing. The registry shall call for the scanned copy of the records. Legible scan copy. Both के scan copy ऐसे एकेबारे कहाँ रहेंगे? Legible scan copy of the records of sessions case number 84/2018 from the Court of Learned Session Judge Kasar Silsher. The connected bill prayer of the petitioner shall be considered on the receipt of the 11 records from the Learned Trial Court. List in the week commencing from 27th of August on the date to be fixed by the registry.
May I please?
Earlier matter was heard by Justice Polita.
Yes, my lord. Earlier, your lordship has heard.
No,
Not this lordship.
no, your lordship. Earlier the matter was not heard.
No. Earlier, the matter was heard by one lordship.
Hearing court is like paucity of time, sir. There was paucity of time, your lordship.
Yes, Mr. Chetri.
My lord. My lord, the complainant in the complaint case have stated that the issuing process in the NI Act
is an illegal.
We are not on that.
I'm not on,
No, we are on that. The legal notice was issued.
my lord, after due process of 138 procedure, my lord, whatever the codified law has given, accordingly, we have filed the complaint case under section 138 NI Act. One provisions is there, 141, my lord. This is not an offense of an NI Act between A and B. This is an offense done by the accused, who is a company, my lord, represented by his directors. So the offense comes under 138 with 141, my lord. That is the law says, my lord. So his ground which he has taken in his plea before this honorable court under 482, my lord. May I apprise, my lord, the page?
There is a complaint.
I have not annexed, your lordship, because I have not received the copy. It is in the record, your lordship. Your lordship may kindly go at para 4, 8 and 9 of the complaint.
It is a duty of the council who comes under 482 must annex the copy of the complaint, my lord.
They are admitting that after the issuance of notice, we have paid them. And after that, they have filed this case.
Both the parties
And
are,
we have also intimated it to the council who had issued the notice. He is acting like a recovery agent, your lordship.
my lord, these parties are business partners, my lord, and they are dealing the
They are not partners, your lordship.
electronic goods, my lord.
They are not partners.
They have stated categorically in their paragraphs, my lord.
Mr. Chetri, what was the demand made in the legal notice?
My lord, demand made in the legal notice is that payment of my check bounce amount, my lord.
What is the amount?
Amount is 50,000, my lord.
They ask you to take your seat. Now, that amount, you have admitted the fact that the accused number one.
My lord, beside this, my lord, there was a business transaction, my lord. I have
Was it in the
categorically
legal
stated,
notice? That is the reason we are asking you.
my lord.
Have you mentioned in your legal notice that what is the due to be paid? Because 138 proceeding is only on the check bounce case, right?
My lord,
So the amount that was bounced or could not be cleared is of 50,000.
my lord,
Against which you have issued the notice
my lord,
on 28th of April 2023, giving them time in 15 days time.
My lord.
29/4, they have received the notice and cleared the amount on 9th of May.
my lord,
So you have admitted that.
my lord,
Now, here you have asked for 141, 142 and 143A.
my lord.
Let us see the provisions.
That is the provision, my lord. 41, my lord. 148 is the top detail.
Not. It's a- Mr. Secretary,
My lord,
come to the proviso of section 138.
my lord. May I read it, my lord?
Please, only the provisos, right?
My lord. Provided that nothing contained in this section shall apply unless A, the check has been presented to the bank within a period of 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. B, the payee on the holder is due course of the check, as the case may be, makes a demand for payment of the said amount of money by giving a notice in writing to the doyer of the check within 30 days of receipt of information by him from the bank regarding the return of the check as unpaid. C, the doyer of such check fails to make the payment of the said amount of the money to the payee, as the case may be, to the holder in due course of the check within 15 days of receipt of the said notice.
So, to constitute an offense under section 138 of the NI Act. If somebody complies of this ABC, right?
My lord.
Will it be in violation of 138 Act? Now, after reading B and C, it can be seen that the accused number one, the petitioner herein, have paid that amount, right?
My lord,
They have
that is
paid
the
the
point,
amount.
my lord.
They
That
have
is the
paid the-
point your lordship has rightly pointed out, my lord.
Then please come to 141.
Yes, my lord. May I read it, my lord? May I read it, my lord? Offense by company, one, if the person committing an offense under section 138 is a company, every person
Don't
who.
go further, don't go further. So here is a company, the petitioner is a company. He
Yes,
paid
my
the dues after receipt of the notice within 15 days. Then where is the offense under section 138?
Now, my lord, may I take it, my lord? Your lordship has rightly pointed out, my lord. Now, my lord, when your lordship will see my check, my lord, the check, they have stated also, the check was
What is the
given
case?
on.
Read B and C of 138. Read B and C of 138.
Yes, my lord, the
Provide
payee on
B&C.
the holder in due course of the check is the case may be makes a demand for payment of the said amount of money by giving a notice in writing to the doyer of the check within 30 days of the receipt of the information by him from the bank regarding the return of the check as unpaid. C, the doyer of the such check failed to make the payment of the said amount of money to the payee as the case may be to the holder in due course of the check within 15 days of receipt of the said notice.
So here, whether the petitioner, accused number one company, failed to pay you the amount of 50,000 has been as per the notice.
Yes, my lord. No, my lord. I do not agree, my lord, with this. Because, my lord, he says.
Within 15 days, whether the accused number one company failed to pay you the amount that you have demanded
Yes, my lord, fail to pay it.
within 15 days.
Yes, my lord. That is why they say after giving the notice, I have remitted. It is admitted fact, I have remitted. So many ledger accounts were there. Now who pay what pay?
What was the demand?
Yes, my lord. Demand was that 50,000 check amount. This was given by Manisha Jain, who is the authorized signatory. She is one of the director of this Barali brother. Now, when this check was given, it was on 12/4/23.
You are not on that. Come to B and C.
Yes, my lord, B and C, my lord. B says when the check has been presented to the bank within a period of 6 months on date on which it is drawn within the period of its validity, whichever is earlier. B, the payee, the holder in due course of the check as the case may be a demand of payment of the said amount of money given by notice in writing to the doyer of the check within 30 days of receipt of information by him from the bank regarding the return of the check as unpaid. C, the doyer of the such check failed to make the payment of the said amount of money to the payee as the case may be to the holder in due course of the check within 15 days of the receipt of the said notice.
That is why we want to know from you whether
My lord.
the accused number one company failed to pay you that amount which you have demanded to your within 15 days from the date of your notice.
That is why trial court has taken cognizance and issued notice to the opposite party who has promptly came before this honorable court under 482, my lord.
So kindly tell us whether any offense under section 138 was committed by the accused number one.
Yes, my lord, we have given notice, my lord.
To be an offense under 140, 141.
My lord.
There has to be an offense committed by the accused under section 138.
My lord.
Here you have received that amount of rupees 50,000.
From whom?
From the accused number.
From whom? He has given a screenshot. He says he paid it. Now who paid it? That is very transparent from his petition, my lord. That is on page 18, my lord. 18, 19. 15, 16, 17 is the legal notice. Annexure 4, 18, my lord. 18 and 19. Let him clarify who paid it. which director paid it. After the check payment, check bounce by a prudent person representing a company, and later on by a board resolution, they form the company and makes a director itself. So let him come, let him submit before your lordship, my lord. Who paid this money to whom? Where is the name?
Your lordship may kindly peruse page 25 of the affidavit in opposition. Para 5.
First, lordship may verify this thing, my lord.
That
This payment, my lord. What's the payment, my lord?
That with regards to the statements made in para 4, the answering respondent begs to state that as the check as admitted by the was issued and head bound and for which the legal notice was issued, and upon receipt of the same, the petitioner so transferred money to the respondent number 2. Their case is that we have not said stated it about whether it was a pleasure or it was against the check.
That is why I'm saying that
But
that
the
the
notice
amount
was
which is
issued
we
only
have
for the
sent it
check
into
amount.
what, so which amount or which, who has given this check?
And this is also blatantly they are lying on oath, because immediately we have intimated the counsel who had issued the notice. We see that page number 19. He, on the contrary, he is asking more money. Is it a part payment? When I expect you? Page number 19 of my application, your lordship. 19. This is a malicious prosecution, your lordship.
No, my lord, it's a correct prosecution, my lord.
Even in the notice, they have stated that as part payment. I have issued the check of 50,000.
Okay.
My lord,
Anything else?
with all respect, my lord.
Yes, you have made the payment of 50,000.
Yes, your lordship.
So tell us, is it required to clarify that you have made it, since you have made it NEFT to NEFT? Is it required to make that this is against that particular demand notice?
Yes.
Your lordship, they themselves have admitted that. They themselves have admitted in para 5, and within 50 days, the section 138 is very clear. If you receive demand notice, within 15 days you pay. If you don't pay, then the case will initiate against you. So within 15 days, I have made the payment. I have also intimated it to the concerned advocate who issued the notice that I have made the payment of 50,000. That is on page 19, your lordship. It is who demanded more money. Is it part payment? When I expect you? Page number 19, your lordship may kindly. And in their affidavit in opposition, they remain silent about it.
No, I've stated in my ground clearly.
No, you have nothing.
Lordship may sit
Regarding
down with affidavit in opposition, my lord, my lord.
They have stated nothing. They have remained silent. Para 5. On 9/5, the petitioner number 3 sons, utilizing him, sent a WhatsApp message to the mobile number of the advocate who had issued the notice. This message included a screenshot that clearly demonstrated the confirmation of payment made to the respondent number 2. However, to the petitioner's surprise, the advocate responded by asserting that the payment was merely a partial one.
That is why 41.
That is why they are
141.
working as a recovery agent, your lordship. Malicious prosecution is this way.
Okay. Yes, Mr. Secretary, anything else?
My lord, the ground, your lordship, will last perusal of the ground, my lord, with all respect, my lord. What he has stated in his, before this honorable court, and what are the grounds he has taken, my lord, in his petition 482, my lord. May I take your lordship to the page 9, the ground, my lord. The lordship got it, my lord. Now, my lord, from the criminal complaint under 138 NI Act, and the continuation of the proceeding pursuant thereto is an abuse of the process of law and amount to be malice and prosecution against the petitioner. Now, when and for 138 NI Act comes, 138 NI Act comes complying all the provisions, then only the court takes cognizance and issue process comes. B, further, the learned judicial magistrate Kamrup at Guwahati erred in taking cognizance issuing process against the petitioner in respect of check already paid and discharged. That is the disputed facts, my lord. C, for that the end of justice would be met by interference of this honorable court in exercise of any jurisdiction under 482 to prevent the abuse of his process and to secure the end of justice. D, for that the continuance of the proceeding under 138 NI Act would cause grave and undue hardship prejudice to the petitioner who are already facing loss of reputation and time and money in defending. Now the reputation, they say, issuing of check to me bounced by a company's director representing, at that time they did not notice, they have no knowledge, the complete knowledge, my lord. So, my lord, now they say all these things. E, for that the malified of the respondent number 2 and 3 in pursuing the complaint case for the same check, despite encashment and settlement, encashment, the word encashment they have stated, my lord. Encashment and settlement is apparent from the facts. Now your lordship will have to encashment and the circumstance. And this is a fit case of causing criminal proceeding. These are the grounds taken by them. Now, my lordship, my lord, my affidavit in opposition file, my lord, the grounds be taken and replied to his petition, my lord. The lordship, may I submit, my lord. Now, my lord, grounds. For that, the ground taken in para A is not as per law. The petitioner has not replied to the legal demand notice. Statutory, obligatory, mandatory of the legal notice. I leave up to your lordship. Of the respondent, the petitioner is due to respondent number 2 an amount of 5,88,000, and the issuance of the check is admitted by the petitioner. Hence, no interference is required by this honorable court. For that, with regard to the ground taken para B of this criminal petition, false denied, the honorable court below had rightly taken cognizance upon perusal of the record and hearing the party and issue notice upon the petitioner. Hence, no interference required by this honorable court. For that, with regard to the ground taken para C, the answer does not beg to state the non-reply of the legal demand notice. Had they been replied to my legal demand notice, my lord, the matter would have been settled once for all. As your lordship already query whether for that bound check amount you have paid, where it is. The lordship had already made a query. That is the fact. My legal demand will compel the respondent complaint to file this case. Non-replying of the legal demand notice. That is why in our proceeding to take the criminal court in motion, that is why legal demand notice is being given. That is a part of the criminal proceeding to go in an action. The same demand the trial. Hence, no interference required by this court. For that, with regard to the ground taken in D, the answering respondent begs to state that payment made through online does not amount to check amount. That is why I have stated in my ground, my lord, that reply number 1 and the check amount. That is the fact, my lord. Does not amount to check, as the complaint had huge outstanding dues against the petitioner, who is clearly stated in complaint petition in CR case number pending before the judicial first case. Hence, no interference required by. As your lordship has already made an inquiry, my lord, whether the check amount is a remittation, where it is. Let him show.
Whether huge amount was demanded or
no, check amount.
There was
check amount.
no such
check
demand
amount.
for the ledger amount.
Check
Only
amount.
for the 50,000 amount. And the question is whether I have informed them or not.
Only when he will ask you to say submit, can you submit? Yes, Mr. Secretary, go on.
My lord, may I proceed, my lord? Now, my lord, he submits before this honorable court that I have made payment. I have not denied it, whether it is a ledger amount or he pays to the accounts. Now, let it come to the his petition, page 18, paragraph 4, annexure 4, my lord.
Yes.
Lordship got it, my lord. Annexure 4. This is the transfer, my lord. Now, from this record which he has annexed, my lord, where it states that it is a check amount, my lord, that is number one. Who pays for whom? What status of the person who gives this? Annexure 4 and 5. That is to be looked up by the lordship, my lord. That is why it is a fifth case to go to the trial. There they agitate, there they makes the facts clear that this is the check amount which I have given and the same has been remitted. Now, based on this, they have come under 482.
Okay.
That is why 141 is been invoked by in this 138, my lord. As the lordship has already made clear, 138 B and C.
Yes.
That is why that B and C is been hit by 141, my lord.
Okay.
With all respect, my lord.
Mr. Jha, you have heard Mr. Secretary. Now just clarify two things. From page 18, come to page number. How the respondent number 2, the complainant will come to know.
Your lordship?
From the page 18.
Yes, sir.
How the complainant will come to know that it is the accused have deposited this amount against the demanded amount.
Yes, your lordship. Your lordship may kindly turn to page 19. He is the concerned advocate. I have sent him the WhatsApp message. to advocate who issued the notice. I have sent him the screenshot. After sending the screenshot, he is saying, is it part payment?
Then,
Page 19, your lordship.
then what was your reply?
I did not reply, your lordship,
That is the fact.
because 138A clearly says, make the payment within 15 days. And in normal course of business, sometimes check bounce.
That's a different issue.
But after the,
That is why we ask you how the complainant would come to know that the accused have deposited this amount of 50,000 against the demand notice of 28/4/2020.
in page 19, your lordship, on 9 May 2023 itself, when I deposited the amount, I sent the screenshot to the concerned advocate who issued the notice. And moreover, they are also admitting that on 9/5/2023, they have received 15,000 in their complaint petition also. Application also in para 8, they have stated that they have given 50,000. And there was in para 4, they have stated that as part payment, we have given 50,000 rupees check of the ledger amount.
That is the fact.
Part payment, then only we have, after the check bounce, we paid.
Okay. Or Mr. Andrew.
The lordship, my name is Mbedia.
Mbedia. Mbedia. BRI. For the petition. And Mr. Bosso, you are there?
Yes, sir.
Mr. Bosso, Senior Public Prosecutor. Operation number 1. Also heard Mr. K.D. Chetri, Learned Counsel for the respondent numbers 2 and 3. List them. 21st of August. For necessary law.
With all respect, much obliged.
Much obliged.
This is an application for custody of the jewelry shop, my lord. That is my lord, that is my prayer was elected by the trial court, my lord. Thereafter I came before lordship, my lord. The jewelry shop is the only source of income, my lord. I am depending whole family on it, my lord. In a criminal case, my lord, my shop has been sealed by the Deputy Commissioner, my lord, Municipal Corporation on December 2023. Since January, it is under sealed, my lord. So I pray, my lord, I may be allowed to run down my shop, my lord, because this is the only source of income, my lord. I pray, my lord. Refugee file করেছিল পয়সা না I have been directed to file an application for aiding one my lord Kushoram Rompi, who was the first party in an agreement with the landlord, my lord. I made an application making him responsible of 5, my lord. I have filed this application before lordship, my lord. And impugn order is my lord, page 35.
Yes, Ms. Sharma. See, you are aware that if somebody is being aware that
My
goods
lord,
is stolen goods. There are provisions in the IPC
Yes, my lord.
to prosecute against
Yes, my lord.
that particular accused who knowing fully well purchase that stolen goods and use it for his own purpose or some other purpose for personal gain. Now the magistrate writes a letter to the GMC
My lord.
for sealing of the jewelry. Right? What should be the procedure for sealing of such shop?
Sealing, my lord, would be
How to be sealed?
as per provisions of CrPC, my lord. The police officer has to.
The person who purchased the stolen good and used it for own purpose arrested. And he'll be prosecuted under the specific provision of the IPC.
My lord.
Now, there is a prayer by the accused was arrested in connection of purchasing stolen gold. He has asked for the Zimma of the other gold in that particular jewelry shop.
My lord.
Right? You have rejected. The learned magistrate have rejected. You are appearing for GMC.
My lord, actually, I should not be appearing for GMC because GMC has a standing counsel, my lord. Nevertheless, I have received one instruction that has been placed before your lordship.
Just a minute. When the petitioner was released from custody, he was arrested, right?
My lord, I have been studied in paragraph, my lord, or paragraph 6, my lord. I was arrested on 31/12 and released on 24/24, and I have submitted document, my lord, 25/24. Paragraph 6 and 7, my lord, I have stated in it.
Paragraph 7, my lord, the petitioner stated that he has submitted necessary documents
Yes.
to the opposite party number 3. In terms of the notice dated 22nd 1/24, which was given by the GMC, my lord.
Yes.
But as per my instruction, my lord, no documents, no any relevant documents have been received by the GMC by the petitioner, Moti Jewelry.
I have stated in on affidavit matter, paragraph
There
7.
is no annexure also.
Where is application for your Zimma? Where is your application for Zimma?
Zimma, my lord, that is my lord. Import order is page 35.
Where is
my
your
lord.
application?
Yes, sir. Before the trial court, I have filed an application for Zimma that was rejected by the trial court, my lord, page 35.
Have you annexed a copy of the application here?
Application of copy to not.
But it is not with me. It should be.
Records are not here. Can you give us a copy?
I have not submitted, my lord.
Yes.
Even notice. Petty official, my lord, copy of the petition, I have not annexed, my lord. I am sorry, my lord. Even submission of documented.
It is 7/3/24.
That's a, take a picture of one. What? Like, we go in give man hand. Oh, I think it's right to believe. My lords.
Application for.
Heard Mr. S.K.
My
Mohammed,
lord,
counsel.
on application having submitted before the, my lord, Commissioner Guwahati Municipal Corporation, my lord, for withdrawal of the seal and release the jewelry of petition. I have submitted. my lord. No, but thank you, I can. My idea got an
The application of copy as an of matter.
visited High Court, court given nine. So I can visit there. Extra copy.
Pursuant to the order, hardly, Mr. S.K. and Mohammed, counsel appearing for the petitioner. And Mr. E. Vishal, on everything for the prosecutor. For the respondent number 1 and 4. Also heard annex 2 sermon and dominant group for the respondent number 3. Pursuant to the order the 2106/2024, the petitioner has filed an affidavit. Additional affidavit in this revision petition to implead Kushoram Gogoi, brother of late Benu Rongpi, / brother-in-law of respondent number
It will be performed in a Hindi.
Two. বেনু রংপুর লিখছেন না এই নামটা লিখে দুটো রংপুর এই এসে রংপুর son of লেখা অহর রংপুর AHL brother of late Benu Rongpi / brother-in-law respondent as party respondent in the present proceeding. Party respondent opposite party number 5 in the present proceeding. Considering the order dated 2106 in this proceeding. Said Kusaram Rongpi, son of such and such. Be implemented as part opposite party number 5 in the present proceeding. The petitioner is directed to take first steps on the respondent number 2 and newly into the respondent number 5 by registered post with AD. Oh, somebody has appeared. Okay, upon the respondent number newly into the respondent 2 newly to respondent number 5. Learned counsels, Mr. M.H. Shaikia, Mr. N.H. Major Bhia and Mr. R.I. Bhia has already appeared on behalf of the respondent number 2 on receipt of notice of this petition. Petitioner is directed to steps on the newly implemented respondent number opposite party number 5 by registered court to JD, providing its is native. Correct and for this with the honor before. Take steps on the opposite party number 5 honor before 26. Registers are also all for the records, scan copy of the records of Zimma petition number 6730. And the report of the investigating officer in Bajista case number 850/2023. That was called for by the learned judicial magistrate first class, sub-divisional judicial magistrate in Beckett Southern number 2. They say Zimma petition number 6730. Referred by the petitioner. The entire record for you. Very liquid, the land by order the 19/02/2024, rejected. List on 24. 29th of August.
My lord,
Yeah, 29th will be too long. 28th of August, 20 August.
my lord, for respond number 3, standing council GMC,
Why? It's a Guwahati Commissioner, Guwahati Municipal Corporation or Guwahati?
Deputy Commissioner in charge Dispur Zone, Guwahati Municipal Corporation. So my lord, respond number 3 will be represented by the standing council GMC.
Standing Council GMC is only ex Bora, I believe.
Yes, my lord, I think so. Shantanu. Yes, my lord.
Ms. Sharma, learned government advocate Assam. Submitted. That Guwahati Municipal Corporation has its own standing counsel. And in view of the above, in place of Honorable Assam, they say respondent number 3 is to be represented by standing counsel GMC. Registry shall reflect the name of standing counsel GMC for the respondent number 3 in the cause list having decided. The report. Do you have a photocopy, Ms. Sharma?
Yes, my lord.
Give it to us. This is your original copy. You don't like to have it. If you do not have, we'll make a photocopy. Do you have a report?
Photocopy is marked, but
Doesn't.
marked for it.
The that is for you. That's why. The report of the report of the Guwahati Municipal Corporation dispute June dated 04/06/2024. Placed by Ms. U. Sharma, London Government of Assam for the respondent number 3. Be kept as a part of that list accordingly.
My lord, may I leave the lordship's indulgence, my lord? Item number 30, my lord. Can it be taken on day after tomorrow, my lord?
Mr. What is the urgency?
Urgency is after the response, my lord, but then the matter is tied up since long, my lord. No, it's a special application, my lord.
30 will be, day after tomorrow will be little difficult.
Friday.
All these matters, I can say, can only be considered only after 5th of August.
5th of August.
After 5th of August, since 5th of August, not in the coming 2 weeks.
My lord.
Because board is full and there are some.
I understand, my lord.
So.
Then my matter may be taken up on the 7th of August, my lord.
Section from the
6th of August, my lord.
You just tell us which are the matters where there is an interim stay order. That will take care of. Rest.
In my case, there is no still, it will be on the 6th of August, my lord.
Will indicate. Item number 30.
30, my lord. 30. 30. My lord, I am appearing for item 35, 25, I am the amicus. But what has happened in this case, there is a jail appeal of 2020. Person is convicted in 2019. I have calculated, even excluding the set-off period, my lord, is now 4 years, 8 months, 13 days. Till date. And set-off period of 4 months is there. So, my lord, it fixes this matter some on a fixed date, my lord. Perhaps this person.
This is what is the conviction?
Conviction, my lord, under 3042.
Period.
5 years, my lord. Already 4 years, 8 months, 13 days. Including setup to behavioral. Excluding setup.
Day after tomorrow.
Day after. Yes, ma'am. I was just about to indicate also, my lord. Perhaps this requires.
But Mr. Gogoi, just make a mention in the morning.
My lord.
Okay.
My lord, very well.
Because otherwise, lots of matters will come. We do not know
My
again the
lord.
matter will proceed. Because these
I'll
matters
mention.
has to be.
I understand.
Make a mention at 10:30.
My lord. All right.